Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1073 et al. Sinclair Wyoming Refining Company LLC and Sinclair Casper Refining Company LLC petitioners versus Environmental Protection Agency, and case number 22-1074 et al. Sinclair Wyoming Refining Company LLC petitioner versus Environmental Protection Agency.
Morning.
May it please the court, I'm Michael Houston of Perkins Coie. I'll be addressing the arguments that are common to all of the petitioners in these cases, and then I want to be sure to save a few minutes and talk about the eligibility issue that affects only Company A. My colleague, Mr. Delquil, will address Refinery B. In 2021, the Supreme Court rejected EPA's argument that Congress intended to sunset the RFS hardship exemption for small refineries, just like the petitioners, that are critical to domestic energy security and that are pillars of their communities. But just a few months after EPA lost in Holly Frontier, it set out in the denial decisions to eliminate the hardship exemption itself. First, by ignoring the statutory deadline to decide these petitions, and then by denying every single one of them. EPA did so based on the staggering conclusion that the costs of RFS compliance for the smallest refineries in the country are exactly the same as on some of the largest vertically integrated oil companies in the world. The Fifth Circuit recently explained why that conclusion is, quote, so implausible that it cannot be ascribed to a difference in view or agency expertise. It directly contradicts EPA's prior findings and rests on premises that the record proves to be false. EPA disregarded the statutory text by looking only to the costs of compliance and refusing to consider refineries' individual economic circumstances. And EPA's decision is unlawfully retroactive. These refineries justifiably relied on EPA's consistently adopted framework for adjudicating hardship petitions. EPA was not permitted to entirely jettison that framework and adopt a wholly different one years after the compliance years were over, when the refineries could do nothing about it. The Fifth Circuit got all these issues right, and this court should rule likewise. The court should vacate the denial decisions and remand with instructions to the agency to either grant the hardship petitions or adopt the EPA's alternative compliance approach. I welcome the court's questions.
Speaking of the Fifth Circuit, there's no venue dispute left in this case, right?
That's correct, Your Honor. I don't think there's ever been a venue dispute in this court. I think the parties agree about that.
Just to sort of understand the scope of your position, you appear to concede that the RIN pass-through principle does hold on average across the industry, but as I take it, your primary complaint is that even if it does occur on average, it doesn't apply equally to each of the small refinery petitioners for various reasons.
I think what EPA said, Your Honor, the logic of their position is that they believe they have observed data that supports RIN pass-through on average across the entire industry. If the court looks at the studies, the only two studies that EPA has ever relied on to justify this, the Burkholder study and then the point of obligation decision in 2017, you will see, and the court will also see in Elan, the case that the EPA relies on so heavily, the conclusion in the record there was about general observations of pass-through, that it occurs on average.
But you don't need to dispute, and I don't take you to be disputing that their studies show, as you say, at most, price spreads reflect changes in the calculated RIN obligation on average. RIN costs were fully passed through on average. And then you argue, and I'm looking at page 67 of your brief, none of the studies EPA cites look specifically at small refineries. They say nothing about individual refineries. So even if the industry as a whole is working these through, passing these through, your point is that the allocation or the distribution among small refineries is there's no guarantee.
Yes, that's exactly right. And that is, I think, the whole point of Congress's hardship exemption. Congress recognized that although when it adopted the RFS program, that it wanted a balance. It was the RFS is focused on domestic energy security, but If the RFS obligation becomes so acute that it drives small refineries, which have different structural considerations, and I think that then the goals of domestic energy security will be frustrated. And I think it's worth thinking about exactly what those structural disadvantages are. The biggest one is that small refineries, unlike their vertically integrated competitors, do not have the opportunity in large part to blend renewable fuel. They are captive to the RIN market. They have to go out and buy the RINs from the large companies that sell them. And as the record reflects, those companies make enormous profits doing so. You can see this at JA 13, 468, and 469.
Let me ask you, and I know you dispute this, but if EPA were correct that the RFS program imposes zero compliance costs, then a small refinery could not experience disproportionate economic hardship that is caused by the RFS program.
So I think if it were actually true that every refinery has no cost burden from the RFS, then yes, I think in that extraordinary circumstance. But that is exactly the conclusion that the Fifth Circuit said is so utterly implausible. It just is contrary to common sense.
Right.
It's
so if we, and I'm trying to understand the role of the statutory interpretation in this case, because I'm not sure how we reach the statutory interpretation issue. So if we agreed with you that under the statute, a small refinery may be eligible for an exemption, even if its compliance costs are proportionate. And if we conclude that because of RIN pass-through, no refinery has experienced any compliance costs, then the statutory interpretation doesn't even matter.
So respectfully, Your Honor, I disagree with that because I think it's important to bear in mind that EPA's conclusion, their own argument, is that pass-through phenomenon holds true only if small refineries buy RINs ratably. That is a cornerstone of their.
But if we think that EPA is wrong about ratability, the feasibility of buying ratably, then that makes the denial action arbitrary and capricious, no matter how we understand causation under the statute.
That's exactly right, Your Honor. Yes. So in that respect, they are independent grounds for vacating the denial actions. They are linked in the sense that EPA says our view of causation in interpreting the statute is based on the conclusion that that RFS compliance costs alone are the only thing we're willing to consider, and more specifically, RFS compliance costs when RINs are bought ratably. And
But I don't see how that drives a statutory interpretation. In fact, it seems to obviate the need for a statutory interpretation. You don't need to decide whether it's a cause, a but-for cause, a proximate cause, if there's nothing that's causing anything.
Well, so I think
if there's no harm at all, then the question of how do we understand causation under the statute is just not material to the resolution of the case.
So, I mean, with respect, Your Honor, I don't think I quite agree with that. I certainly agree that if the court rejects the pass-through hypothesis, if the court rejects the premises that underlie it, namely ratable RIN purchases and the fact that all parties can pay the same amount for RINs, which I do want to talk about, the court, that's sufficient to vacate the denial actions. But there is, and even if
in fact, let me just stop you there. We wouldn't even have to reject pass-through. We would just have to reject the ratability.
That is exactly right, Your Honor. That is absolutely sufficient. The only point that I'm trying to make is that because EPA is saying there is no hardship if a small refinery buys RINs ratably, that is tantamount to an agency interpretation, a statutory interpretation, that refineries are obligated to buy RINs ratably. And that requirement appears nowhere in the statute. Indeed, I think the statutory text contradicts it because of the deficit carry forward provision, the provision in the statute that says a refinery can be fully compliant with the RFS if it does nothing in year one and then carries forward its obligation into year two. There's no way.
Why does that have to be? I appreciate your point about the deficits. Bracketing that for a moment, I'm not sure that I follow why, if EPA had rock solid evidence that ratability was feasible and was the way to go, why would it have to be a statutory interpretation that it were requiring that? Why couldn't it just be a reasonable regulatory method of avoiding gamesmanship or shirking or, actions that would cause untoward fluctuations in the RIN market?
Well, because I don't think the EPA cannot add words to the statute that aren't there.
But it can implement the statute.
Of course.
Regulatory authority to come up with reasonable rules.
Reasonable rules, but it can't contradict the specific provisions of flexibility that
Right,
Congress
that's what I
provided.
said, if we were going to bracket that.
Well,
It doesn't need to be a statutory interpretation argument, but it does need to be non-arbitrary.
it needs to be non-arbitrary. It needs to be consistent with the other provisions of the statute. I think respectfully, the deficit carry forward provision, I don't mean to fight the court's hypothetical.
It's important.
It's important, and I think it's the provision that most cleanly explains why EPA's newfound insistence that small refineries buy RINs ratably, even if it were possible, which it's not, as EPA acknowledges, is inconsistent with the statutory text.
I mean, it may be true that if we find the EPA's action unreasonable, that would be a sufficient grounds for vacating. But isn't its reasonableness analysis sort of inextricably connected with its statutory interpretation?
Yes, I think that is a fair characterization of EPA's own opinion. And it's because they say that it's because the way that they interpret the statute is to focus on causation. And they say, we are going to look only to the costs of RFS compliance. We're going to ignore all of the other individual economic circumstances of a refinery that have always driven the consideration of the hardship exemption. Now EPA says we're interested in one thing and one thing only. What are your costs of RINs bought ratably? That's their interpretation of the statute, and that's the sense that because that syncs up with their economic conclusion that RIN cost pass-through is achieved only when RINs are bought ratably, I think it does lead to that conclusion. And it's important for the court to look at the evidence that we put forward. I think I'd like to spend a minute on that, if I might, because ratable RIN purchasing is such a cornerstone of EPA's analysis. As they explain, here's what EPA said about ratable RIN purchasing in 2019. Requiring immediate RIN retirement is, quote, infeasible because, quote, it would be virtually impossible for the market to meet such tight demand for RINs by obligated parties. The reason is because RINs are unevenly generated throughout the year. Take one example, diesel fuel. Much harder to blend biodiesel in the winter. So refineries across the country don't. They blend more diesel fuel in the summertime, in the months when it's warmer. That means that the production of the RINs that correspond to that fuel isn't consistent across the year. There's more available at different times. That's exactly why EPA said it would be infeasible, impossible actually was their word, for parties to be obligated to buy RINs at the same time. And they have said not one word in the denial actions or their brief about why that's wrong.
I think they have a footnote, but we'll get to that. But so you suggest in your brief that buying RINs ratably means contemporaneously with the sale of fuel. But EPA at times appears to mean something more flexible, saying that the refinery that purchases will purchase ratably if it purchases on a systemic, regular basis, the number of RINs needed to satisfy their obligations. So I wonder whether your objections, like the infeasibility of, actual daily retirement of RINs, go away if we assume that regular RIN purchases doesn't mean strictly contemporaneous, but more something that's just along the way.
So if I can make 2 points about that, Your Honor. The first is that EPA's conclusion is that every single refinery in the country, no matter its circumstances, will always experience perfect pass-through. And in order for them to make such a bold conclusion, I think they have to be awfully precise about what they're talking about. And the only way that even as a matter of their own economic theory, that could make sense is if the time that RINs are purchased is very close in proximity, the same day or...
Is that right? I mean, think about sort of, investing on a kind of dollar cost averaging basis. You can absolutely reliably hit the market if you have an investing strategy that, sometimes you'll be a little high, sometimes you'll be a little low, but you do regular. It doesn't have to be every day. And so if that's what EPA really means, do you have a slam dunk
Yes,
argument against?
absolutely we do. And that's because the fundamental reasons why small refineries are not able to buy RINs ratably doesn't turn on whether we're buying them, the same day or a few days later. There are a couple of important facts to bear in mind about why why EPA said it was impossible for RINs to be bought ratably. One is the point I just mentioned a few minutes ago, their own conclusion that RINs are unevenly generated throughout the year. Another critical one, EPA didn't even tell us the volumes. They were late repeatedly, as we explained in our brief at page 13. They haven't even told the market how many RINs a small refinery is going to be obligated to buy. I don't know how a small refinery could be expected to buy on the same day or within a few days if EPA hasn't even told them the number that it's going to need. The third point, there are no sellers for these small lots keep in mind, these are small refineries. Their RINs are many times sold in by the million, by the multiple 100,000. We have refinery petitioners in this case that process 5,000 barrels per day. Cross Oil is a good example of this at page JA 9832. They explain they have contacted RIN sellers to attempt to buy RINs. No one will sell them to Cross in the small lots that it would need them. And that problem is not going to go away.
Who has the burden on that point?
It absolutely.
You argue the EPA, didn't support its finding that small refineries can do ratable purchasing. EPA says you just have to contract. It seems like contracts that's a flexible business tool. And if there are many refineries that want this, I'm not sure I understand why contracts to meet that need would be necessarily unavailable.
Because the RINs are bought and sold on a one-to-one basis. They're not like stocks. You can't just call your broker and transact in RINs. You have to call another one-to-one entity that will sell you the RINs. And again, those transactions are typically done.
So there's no centralized market.
There is not a
There are indices, but there's no.
Correct. That's exactly
place
right.
to go.
That's precisely right. And that's an important way that these small refineries are disadvantaged. If you are Cross Oil and you want to buy 5,000 RINs per day, and you call up somebody who is in position to sell them, and you say, I'd like to buy 5,000, they say, we only sell them by the million. No thanks. That's literally what happened to Cross.
Brokers, and the point that your assertion is that brokers won't touch that?
That's right. EPA has not even attempted to show that that's a real thing. Their only response to this in the denial decisions, and this is, again, a key part of why the Fifth Circuit vacated this agency action. And I think to your question about the burden, it absolutely has to be EPA that has the burden on this point because we commented on it. They said a cornerstone of our analysis is ratable RIN purchases. We submitted comments and said that is literally impossible for us to buy RINs ratably, as you yourself have acknowledged. They responded and said, well, yeah, we understand that you're small, but you can go out and enter a transaction with a broker. They have not actually shown, as the Fifth Circuit explained, that there are such people in the market, that such services exist.
But there aren't? I mean, they responded, and your position is that's not feasible. Is there anything we can look at in the record to know that that's not feasible?
Yes, I think
didn't the agency said it was not feasible, and then they changed their position? So is it not the agency's burden to explain a change in position?
That is exactly right, Judge Pan. But I think
it was much more specific, whether there are brokers who would
so I want to
handle the small side.
I want to direct the court's attention to JA 3896 and 9832. Those are the comments from Placid and Cross, two of the refineries here. They submitted to the EPA comments that said, Placid said, quote, there is no trading house that will offer RINs that matches our small daily production. Cross Refining said, we are only able to buy RINs 1 to 3 times per year, despite the inquiries we've made of multiple brokers. EPA has no response to this point except to dream up hypothetical contracts that they haven't actually shown exist. I do not think that is remotely sufficient to justify the change in position.
And what you're saying is not the support for the stay, but because some of the, I know Cross filed something that was about, we can't do this, but it was about getting everything without a stay. That's not what you're saying.
Yeah, that's right. Yes.
That is what you're saying?
No, I'm sorry. Okay. I believe what I'm talking about are Cross's comments
Yeah.
on the proposed denial action that we submitted to the agency. I do want to make sure and take a few.
I have another question about this. On the, how should we view the Avon case from 2019, right? I mean, obviously it was in a different context, but this court held that EPA's, a pass-through theory in a different context was reasonable. How would you distinguish that
Sure,
case? I mean,
sure.
should that be persuasive to this panel?
I think 2 points about Alon, Your Honor. The first is that the only thing that EPA was arguing in that case, the only thing that the court concluded was that it was reasonable for the agency to take the position that pass-through occurs, quote, generally and on average across the entire refining industry. The court specifically at page 649 and 650 of its decision mentioned the fact that the petitioners in Alon had objected to the economic analysis in those studies, but the court said those claims are not brought before us, and so the court specifically did not address them. It's also not about small refineries at all. It's not about the outliers in the market that are the very purpose of the hardship exemption to protect.
And ask you the maybe the relationship between the reasonableness of the EPA's theory. I mean, if the EPA were correct, if we assume that their pass-through theory works and the RINs can be purchased ratably, does that mean that their statutory interpretation is correct?
No, it doesn't.
Because in a way they've said there are no other economic factors, right? We're basically just left with compliance costs. So if they're correct as a factual matter, that there is this pass-through and ratable purchase, does that validate the statutory interpretation?
No, for 2 reasons. In part because of the reason that we discussed earlier, because that conclusion is premised on a new demand on refineries to purchase RINs ratably, even though EPA hasn't actually shown that that's possible, even though they haven't explained their change of position. So I think that's,
I know you obviously don't agree with that, but I'm saying like if that were true factually.
So even then, I think because even in that circumstance, you would be demanding that refineries comply with the RFS in one particular way when the statute doesn't require them to do that, and another provision of the statute tells the deficit carry forward provision tells them that they're not required to do that. And then the last, I think, actual independent statutory violation is that EPA, even in that situation, even if you assume perfect pass-through, EPA acknowledges that the result of that is going to be demand depression. You're going to depress the demand for fuel. We put in comments that observed, I think, the sort of common sense point that a significant drop in the demand for fuel is going to disproportionately impact smaller refineries more than their larger competitors. EPA refuses to consider that. It says we will not take that into account. I don't think the statute allows them to simply ignore that conclusion, even if they were right about pass-through.
You appear to concede in your brief. I know the word concede makes an experienced advocate quake, but I think you acknowledge in your brief that EPA is empowered to disregard the costs of purchasing RINs non-ratably if the timing of the purchase doesn't reflect good faith, reasonable efforts to comply with the RFS, and that's a quote from your brief at page 53. So if there's some unreasonable action on the part of a small refinery, at least in theory, you say that is something that EPA can take into account. Can you think of an example or just explain to me what would be unreasonable within the meaning of that comment in your brief?
I'm not sure that I can exactly, Your Honor, but I mean, there's a concern there's a mention in the denial decisions about refineries engaged in gamesmanship. I think the record just utterly, entirely refutes that. I mean, for one thing, the idea that every single small refinery before you that's been denied is engaged in systemic gamesmanship is, I think, just ludicrous, and I don't think even EPA attempts to defend that. I think if the agency in a different case were to say, we've looked at something about your individual circumstances, the individual way in which you timed the market or something, and that is the basis for a denial of a hardship exemption, you did something in bad faith, that seems to me to be a much more, worlds away from what we have here.
I mean, we at least have one data point on that in our Hermes decision, right? Where we denied the hardship exemption and basically said that the refinery wasn't proceeding as if it wasn't going to get the exemption and it wasn't proceeding, it was giving out a big dividend.
Well,
it could have been buying RINs.
So I think that's very, very different than what we have here. I do think, though, it's very important to say that the idea of the fact that a refinery that has consistently received hardship relief does not buy RINs is not remotely gamesmanship or a bad business choice in the sort of derisive way that EPA describes it in its brief. Think about if you are running a business, you're like Hunt Refining Company. In every single year of the hardship exemption program, you have received the exemption. And EPA has over and over and over again applied the DOE scoring matrix as the way of determining whether you're going to qualify for hardship relief. And the factors that EPA considers as part of that matrix are either staying the same or getting worse. I think the idea of saying we're actually nevertheless going to go out and buy tens or hundreds of millions of dollars in RINs is just sort of crazy. It might be a breach of fiduciary duty. And even if you did
Although we suggested something to the contrary in Hermes, where we said just because you got the exemption in the past doesn't mean you shouldn't be proceeding as if you're not going to get it the next time.
But Hermes did not have this feature of what this record does. And it demonstrates that companies that attempted that strategy faced enormous business risks because there are petitioners before you who did that. One company lost $2.5 million. Krotz Springs lost $12 million. That's at JA 4857. Kern Oil lost tens of millions and had to sue to get it back. Wynnewood lost more than 10 million, which they're going to tell you about later today in the next case. These are all refineries that attempted what you might call the ultra-conservative strategy. Okay, we believe we're entitled to a hardship exemption, but let's just plan like we're not going to get one. They went out and bought RINs. Then what happened? EPA was late in adjudicating their hardship petitions, and when EPA then granted them, the RINs that those companies spent tens of millions of dollars to buy in some instances are worthless or significantly devalued.
Is the reliance on an assumption that you would receive an exemption under if EPA continued to apply the DOE 2011 matrix the way it had in the past?
I think that is factually accurate, but I would put it slightly differently, Your Honor. The refineries were entitled to know the rules of the game. And when EPA has said over hundreds of times, this is the adjudicatory standard. These are the factors that we will consider. EPA was not permitted years after the fact to say, we're jettisoning that framework entirely, and we have a new one that nobody's ever heard of before, and that comes with a new obligation to buy RINs ratably. Notwithstanding the fact that they previously told us we were not required to buy RINs ratably and that it would be impossible to do so. So I think
With the conservative approach that you just outlined, which is retiring RINs in the event that you don't get your exemption, would that work if EPA actually decided the applications within 90 days like they're supposed to?
if EPA had adjudicated these hardship petitions within 90 days, Your Honor, it would have granted them because at the time it was still relying on the DOE scoring matrix.
But my hypothetical is, what if they just did it within 90 days, would that have been more feasible for your clients?
It would not have ameliorated the injury because in many cases, even if they decide them within 90 days, they're going to be making those decisions either all at once in a batch, and that sends a signal to the market. Now or it's happening right before the compliance period is up. The RINs are significantly devalued. The point I'm trying to make is that there was no way to just sort of play it safe and be assured that we're going to be okay. And if we get the exemption, great. It doesn't work that way. The refineries that tried that strategy in multiple instances lost tens of millions of dollars. Sometimes because EPA was late, but sometimes because it just came close to the deadline.
Can you speak to the fact that what we're talking about now is sort of a RIN market from the past, from 2018, 2017, 2016. And I'm interested in what would happen if you did not prevail in this case. How would your clients be able to get RINs? Because they can't be generated again.
Yes.
And what would happen? And I guess there was some representations that some of your clients might go out of business because of this.
Yes, some of them will. Some of them will. It is an existential issue for some of these refineries. The refineries that, of course, I'm up here representing are in different situations. They're not all similarly situated. Some of them retired, some of them were not able to retire. So what exactly that would have to look like, I think is going to be different across the petitioners before you. What I think I can say is that the impact will certainly for some of them be devastating. And that's described best in our applications to this court for a stay pending this case. I mean, those are confidential, but we have put in declarations explaining why this would be almost certainly the end of the line for some of these companies.
That seems like a different showing. That's saying if you don't grant us a stay, then boom, our compliance obligations, we're facing them today. Whereas there's alternative compliance granted here.
But only, Your Honor, for years 2016 to 2018. And for the company,
There's flexibility for 19 to 21
But
as well.
only with regard to the timing, Your Honor.
Right, well, so that's why I'm saying that the stay showing is not really equivalent.
Sorry, can I get an answer to my question about what would happen if you had to buy the RINs from?
So in the case of refinery petitioners that were not able to retire because they couldn't do it, honestly, I'm not exactly sure. It's going to have to be a conversation we would have to have with EPA, because you're absolutely right. It is obviously impossible as we sit here in April of 2024 to acquire RINs. Let's set aside the ACDA years, 2016 to 2018. It's not possible for us to go out and get RINs for 2019. Now there's, EPA says, well, we have the alternative compliance demonstration approach. We have the alternative RIN retirement schedule. They're tinkering around the margins, but there's no way around the reality that what that would mean is the court and EPA saying to some of our clients, you owe multiple hundreds of millions of dollars. And there's just no way that that some of these small refineries, which operate with low margins, are going to be able to survive that kind of imposition. That's the
so
consequence.
what is the relief that the small refineries are seeking on the retroactivity claims? An amendment to the alternative compliance actions, a new alternative compliance action covering 2019 to 2021?
That would I think that would resolve the harm for the refineries that I represent that are before you, Your Honor. Yes, an extension of EPA's own recognition that at a certain point, too much time has passed. You can't unring the bell. You can't unscramble the egg years and years later. That was their conclusion with respect to the alternative compliance demonstration approach. I think it was exactly right for that year, but the same thing holds true for these years too, that we're talking about, generally mostly 19 to 21. And their refusal to grant us that relief in the face of their own indisputably illegally late action is itself arbitrary and
You
capricious.
talk about and we've seen this in Lord knows, in cases where EPA is not meeting the 90-day
Yes.
deadline. Why isn't your primary recourse to bring an APA claim for action unreasonably withheld under 7061?
Some of the refineries have done exactly that, Your Honor, and there are actions pending in federal district courts along those lines as we speak.
Anything happened in any of them? And is that a new phenomenon that hasn't been done in the past?
It has been done. I mean, I can tell the court, because I've litigated some of those cases, that, for example, with respect to the 2022 compliance year, we had to do just that. Multiple refineries had to sue EPA and say, please follow the law and grant us these hardship exemptions, which, when you refuse to grant them, makes it really, really difficult for us to run our business, much less to buy RINs ratably. EPA, after some litigation had gone on, agreed to a date when they would commit to putting out those decisions, and they were able to be dismissed. But yes, that's the sort of thing that we have to happen. It's not, I will say, it's not easy, and EPA resists those actions. They do not, sort of just universally acquiesce to putting out these decisions. And I think what that reinforces, Judge Pillard, is you're absolutely right. This has happened again and again and again. The GAO report describes just how often EPA has been late. They're going to continue to be late unless the court shows them that there are consequences for that.
What exactly is supposed to happen? Like, what ideally would you propose? So of course, that when there's a change in administration, the EPA can take a different approach to how it implements the RFS program, right? As long as it's consistent with the statute. And I'm very sympathetic to your idea that these small refineries and all refineries need some predictability. But there have been intervening judicial decisions. There's been a change in administration. How is what would be the lawful way for the EPA to impose or to change its approach to RFS compliance?
I think so. Judge
Do
Rao.
we have to do rulemaking? What exactly? Because obviously, the whole system contemplates change and
Yes.
political accountability. So what do we do with that?
Sure. I think if the agency wants to have a new framework, I don't mean to call it a rule, but they want their new interpretation is all obligated refineries, small refineries, must go out and purchase RINs ratably.
That is not their position. Their position is that it is possible for small refineries. And again, we may disagree with that assumption, but they're not saying they must purchase RIN.
Well, but they're saying if they don't, they will not be eligible for a hardship exemption. They will refuse, in their words, to consider the costs of RINs bought non-ratably because they call that, quote, a business choice. So they're saying you have only one legitimate business choice. You must go out and buy RINs ratably. I think if that's going to be the new policy that is adopted, at the very minimum, they must give commenters an opportunity to comment on that, for us to explain why we think that's inconsistent with the statute, for us to reinforce further our evidence that it's impossible for us to do it. And assuming that they could do that in a lawful way, they have to apply it prospectively. They can't invent a new requirement of ratable RIN purchasing in December of 2021, which is they did, and say we are going to be held liable for failing to meet that standard back in the 2019 compliance year. That is just fundamentally unfair action.
Would it work for your clients, or would it be an appropriate way to handle this if we agree that the statute does require the economic hardship to be caused by RIN compliance, but saying purchasing non-ratable RINs would be a cost of compliance so that you could still apply for an exemption?
Well,
would that address your concern?
No, it would not, Your Honor, for a couple of reasons. I mean, the first thing is EPA has not substantiated the core premises of their pass-through conclusion, one of which is ratable RIN purchases. But another one that we haven't talked about yet is EPA's conclusion that all parties pay the same amount for RINs. EPA did not attempt to substantiate that conclusion, even though they alone possess the data that would enable them to evaluate it.
I think they did. I mean, they said this is a nationwide market. There have been all these claims that, we're local, we can't send blended fuel through pipelines. And EPA says, no, there is a national market and everybody that doesn't account for changes over time. But on a particular day, I think they've established that there is a price and that everybody pays it.
I have to emphatically disagree with that, Your Honor, because I think it's a factual question. Do small refineries pay the same amount to buy and sell RINs as the largest competitors? EPA says, yes, they do. And our pass-through hypothesis holds true only if that fact is true. But EPA did not actually evaluate whether that's true. Just saying there is a market doesn't address the factual reality, what prices were paid for these RINs. They have the data.
Then, I know it's not on the record, but they then in December went back and addressed the data and came up with results that are consistent with the evidence.
Respectfully, I don't think that's right, Your Honor. In fact, I think it's the opposite. When the GAO said you didn't, first of all, commentators, so I'm not asking the court to rely on the GAO report. Commentators said you have RIN transaction data that will prove whether it's true that small refineries and large refineries pay the same for RINs. Please evaluate it. Please show us whether that is in fact true. EPA refused to do that. I think that is when the arbitrary and capricious violation was complete. But then after that, the GAO said, we've studied that data and we think it's wrong. EPA reacted with the new RIN price analysis that Your Honor mentioned. But the RIN price analysis's conclusion was that small refineries pay sometimes up to 7.5% more to buy RINs. And that adds up because we're talking about sometimes hundreds of millions.
That's not how I read the conclusion, but I take your position and your page site for that.
For the
7.5.
Sure, I refer the court to JA 3479.
Could I complete what I was asking you before, which was, it seems to me that if non-ratable RINs can be the basis for a economic hardship exemption. Why can't your clients then say, if we are to buy RINs now, we're talking about past RINs and the prices are going to be through the roof, or they don't exist, et cetera. It's a cost of compliance that it just seems to me that this would be a way for the agency's statutory interpretation to be correct, but you could still make hardship petitions based on the need for you to purchase non-rateable RINs.
So I think Your Honor is describing a vision of the hardship exemption that EPA does not agree with. I don't.
No, I'm asking you, would that work for you? If we were to interpret it as that it has to be the caused by RIN compliance, but RIN compliance is not limited to rateable RINs. It can be non-rateable.
So I think that would go a long way towards.
That's my question.
Yes, it would go a long way. I think the only thing I would add to it is that I do think that the statute requires EPA to take account of other economic circumstances that are affecting the small refinery. I think that is inherent.
I understand that, but
Yeah.
my question to you is, if we agree with their statutory interpretation, but interpret cost of compliance to include not just rateable RINs, but non-rateable RINs, would that be a way to sort of address this situation in a way that would be more palatable to your
It
clients?
would be more palatable. It would go a long way. Respectfully, I don't think that it would solve the problem. I don't think that that would still be a lawful interpretation if what we mean by that is the agency is going to refuse to consider individualized economic factors, things that have always grounded.
I know that that's your first choice, but if we were to agree with the statutory interpretation, but not with the way they apply it in terms of the way they define cost of compliance, that would go a long way towards.
It would go a long way. I would still think that it would certainly be necessary to vacate the denial decisions. And again, I mean, I don't want to fight the court too hard on this, except I do think it's important to say, if a refinery experiences a tornado, then that is an individual economic circumstance affecting the refinery that I think is quite obviously maybe going to make the cost of RFS compliance disproportionately hardship that refinery in that year. I think that's just inherent in the nature of a standard adopted by Congress that says, look at the refinery's disproportionate economic hardship in view of all of its economic circumstances. And EPA's express refusal in the denial decisions to consider that kind of circumstance, I don't think there's any way to reconcile that with the statute.
So just circling back on EPA's response to the GAO study, this page you cite is referring to modeling assumptions and saying when EPA used the modeling assumptions that GAO used, which it thought and explained why it thought were faulty, there was then small refineries paid from 5.3% to 7.5% more. But then it goes on in great detail and explains its own modeling assumptions. And it says, you know, we find 1.1%. And they end up saying they think that is trivial. So I don't think that and I think that is consistent with the data that they relied on. And they also, I thought, plausibly explained that the actual data from the small refineries is not easy to standardize. They did end up going through, cleaning it out, and coming up with this response. But if this response is confirmatory of the data that they did rely on, then I don't see the problem. I mean, we have to defer to agencies' technical analyses.
Yes, Your Honor, but the agency has the obligation to analyze the issue in a proper way. This is a post hoc decision, right, that they threw out in response to the GAO. And moreover, I think even if we take EPA's sort of view of the world, the fact that they're talking about different modeling assumptions reflects the uncertainty. I read that to say, we think it could be 1.1%, it could be as high as 7.5%. It depends on what assumptions you put in. But even if it's only 1.1%, we're talking about, again, tens or hundreds of millions of dollars of RINs. It adds up enormously. So if small refineries have to pay even, and I don't think this is supported by the record, but even if it were true that small refineries only have to pay 1.1% more, that's going to add up and it's going to make them disadvantaged relative to their largest vertically integrated competitors, the companies that are selling them those RINs at a profit. They make enormous profits doing so. And that's why what you have seen is refineries across the industry do everything they can to expand their blending capability, because everybody understands it is much, much better to control your own blending and not be subject to the RIN market. One last point about this. RIN prices have spiked dramatically in the last few years. This is described in our brief. It's undisputed. They've gone up tenfold. No one could seriously contend that the cost to blend ethanol into gasoline has gone up tenfold in the same time. And that just shows you that it is much better to have the capability of blending than it is to be captive to the RIN market.
I just have one question about Company A, and
So glad you
that's
asked.
why Company A is not time barred from challenging the 2007, 2010 regulations under which the refinery was obligated to comply with the RFS program before 2010. And it seems to me that the previous owner had every incentive to challenge those regulations when promulgated. The regulations that say you have to submit a letter, something saying that you're a small refinery, because it was subject to and actually submitted compliance.
Your Honor, the company doesn't need to challenge the regulations because the regulations are not the problem. The regulations.
Well, they may be. In EPA's analysis, they're the problem.
But that is entirely new, that conclusion. So we are here, Your Honor is referring to the regulations about the original statutory exemption. We are, of course, petitioning for the ongoing future exemption. The denial decisions at issue here are the first time EPA has ever taken the position that a refinery will be permanently barred from seeking the hardship exemption if it did not receive the original exemption. That's new. And that is an
About the extension analysis that the Supreme Court embraced
so
in Holly Frontier?
I don't think so exactly, Your Honor, but the point is that is EPA. First of all, EPA is totally changing its mind. EPA told us exactly the opposite in 2018. It said, you are eligible. This company is eligible to get a hardship exemption. Now EPA is saying, we've changed our mind. You're no longer eligible. But they want to apply that new conclusion retroactively. But even and you're right that they invoke Holly Frontier for it. But Holly Frontier doesn't help EPA here because this refinery did receive the original exemption. It received it under the terms of the statute. The statute says.
Well, it didn't receive it. It was eligible to receive it.
But the statute, I think the statutory text says the refinery's output, shall be exempt from the requirements of the RFS. Nobody needed to go and do anything in order to get that exemption. This refinery was not a new entrant.
They didn't. They submitted RINs in a compliance demonstration, understanding that without having sought it pursuant to the verification letter requirement of the 2007 rules, that they weren't eligible for an exemption that they didn't seek.
No, Your Honor, they didn't. They retired, but they didn't have to. They were exempt, and
They did that voluntarily.
I think yes, they retired voluntarily. It was owned by a different company.
Exempt.
Yes, believing
the
that
time.
believing that they were exempt. But you're talking about a situation when RINs were priced at a marginal fraction of what they were today. The refinery was owned by a different company. It's a very different circumstance. Again, what was even back then, nobody would have had a reason to challenge that because what was lacking at the time was this conclusion that not getting the original exemption would forever preclude you. And if EPA is going to adopt that new rule, they have to adopt it prospectively. They can't sandbag us years after it's over. The last thing to say about Refinery A, the last thing to say about Refinery A is that the other pillar of their conclusion is that you can aggregate the output of this refinery with another facility 1.5 miles down the road. I think that's just fundamentally inconsistent with the statute and its definition of facility. And also it relies on the processing of a different kind of component. They're relying on the processing of vacuum gas oil, even though the statute specifically says what makes a refinery small is the processing of, quote, crude oil. Thank you.
All right. Well, we've kept you for a long time. That tends to indicate that we've found your answers to our questions helpful. You have reserved some time for rebuttal, which we will allow you to take. And now we'll hear from Mr. Delacroix.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. I'm
Morning.
Mark DeLuquil from the Baker and Hostetler Law Firm, arguing on behalf of Company B, and I'm here to address only EPA's determination that Company B is ineligible to petition for hardship relief. Before I get to the statute, I want to describe a little bit about Company B. It's one of the very smallest refineries in the United States with a crude oil throughput in the relevant time period under 5,500 barrels per day. If it was an order of magnitude larger, it would still be a small refinery under the statute. And Company B has been around for nearly 100 years. So this isn't a new market entrant. This is an existing refinery. And in my view, the only question the court really needs to address for Company B is whether the plain language of the Clean Air Act grants the automatic exemption to Company B at the inception of the RFS program. Under EPA's own logic, if Company B received the initial exemption, it should be eligible to petition for extensions of that exemption on an ongoing basis. And so I think it makes sense to look at the Act. And if you want to follow along, I'm going to be reading from page 8 in the addendum to EPA's brief. And what it says in section 21109A little I is that the requirements of paragraph 2 shall not apply to small refineries until calendar year 2011. That's the statute. I don't think there's any way to read that statute as not granting the exemption to Company B through calendar year 2011. The only criteria is whether it's a small refinery. And we can look at the statutory criteria for small refinery as well. That's on pages 2 and 3 of the addendum to EPA's brief, section 21101K. And it says the term small refinery means a refinery for which the average aggregate daily crude throughput for a calendar year, as determined by dividing the aggregate number of days in the calendar year by the number of days in the calendar year, does not exceed 75,000 barrels. Company B was unquestionably a small refinery under the statute, and as a result, under section 21109A1, the requirements of the RFS program shall not apply to it.
I don't take you to be challenging the regulations.
I'm not challenging the regulations. And I know EPA's.
Didn't EPA ask the refineries to submit a letter to receive this exemption and your client did not?
It asked refineries to submit a letter, but it never conditioned eligibility for the exemption on submission of a letter. Congress granted the exemption. EPA would not have had authority to do that, and that's not what the regulations say. But the regulations, and we can look at that aspect of the regulations. There's on page 21 of the addendum to EPA's brief. It says a refiner owning a small refinery must submit a verification letter to EPA containing certain criteria. But it doesn't say that if you don't do that, the consequence is that you don't receive the exemption. There could potentially be another consequence, but once Congress has granted the exemption under the plain language of the statute, it's not something that EPA can give or take based on submission of paperwork.
Well, surely EPA can impose reasonable regulations for how it administers the program to verify that a refinery meets the statutory criteria.
Absolutely. And if the absence of a verification letter was in a circumstance where there was some question about whether the refinery was eligible, perhaps that could have some legal consequence. But where the refinery is unquestionably, no one is arguing that Company B is anywhere close to the statutory threshold for not being a small refinery any longer. I don't think EPA has authority to do that. But I also want to address the broader question of Section 307B jurisdiction stripping and whether or not Company B ought to have been challenging the regulation. EPA granted Company B the exemption for year 2018 before ultimately reversing its decision. The first time EPA had ever applied its regulations in this manner was for Company B was in the context of the adjudicatory orders before the court today. That's the first time Company B was in a position to challenge this application of EPA's regulations as being contrary to the statute.
Why not back in after 2007?
Because first, the regulations do not clearly disqualify such that Company B would have been on notice. Remember, EPA...
That's a big risk in light of under the regulation 80.1141C. It says if EPA finds a refiner provided false or inaccurate information regarding the refinery's crude throughput, the exemption will be void. And it seems to be not a large interpretive step to say that if EPA finds a refiner provided no information regarding its throughput, the exemption will be void.
Well,
So if you're being prudent at the time.
Well, regardless of the level of prudency, I think the prudence, well, let me say that a different way. The prudency of a refinery not interpreting the regulations the way you are is shown by the fact that EPA, in fact, did not interpret the regulations the way that you're interpreting them in the context of the 2018 exemption for Company B. And
Was that before Holly Frontier?
That was before Holly Frontier. And after Holly Frontier, in the first time that EPA applied these regulations in the way that you're saying, Company B brought its challenge in the context of the order where the regulations were being applied. I want to raise another aspect of subsection C, Judge Pillard, that you just mentioned, and it talks about providing false or inaccurate information. And I think that gets back to my answer to Judge Rao's question a few minutes ago. There may well be appropriate consequences if you have the refinery providing false crude throughput information to losing the automatic exemption, but I think that's a very different situation than where you have a refinery that no one argues didn't meet the statutory criteria. And as we noted in our reply brief, the reason that we didn't submit the letter is because we were not at the time processing transportation fuel. But that doesn't mean that the decision by Congress in section 211.019A that the requirements of paragraph 2 shall not apply to small refineries has no implications for us. I'd like to briefly also address the arbitrary and capricious argument that we raised. EPA's justification for why it made sense to interpret its regulations as to Company B in this manner was that Company B was in the same position as a new entrant to the market and could make all the same decisions that investment group looking at investing in a greenfield refinery would do before putting up a facility and complying with the program, and that's just not the case. This byproduct was something that the market evaporated for precipitously. You can't just dump crude oil byproducts in the back 40. You've got to treat them and deal with them appropriately. And beginning the production of diesel was the only way to do that. So,
All right.
thank you, Your Honors.
So, Mr. Hughes, it would be helpful if you would explain to us how you and Mr. Harrison are dividing the subject matter.
Of course, Your Honor.
Presentation.
I will be addressing points 2 and 3 from our brief, retroactivity and statutory interpretation. And Mr. Harrison will be addressing our remaining arguments, including the ratable RIN purchase arguments. arguments 4 and
Ah, it's
5.
ratable, not rateable.
I hope so.
All right, you may proceed when you're ready.
EPA's decision to deny the refinery exemption petitions was prospective because it addressed pending applications, or was least permissibly retroactive because there was no well-established approach for petitioners to rely on. They do not point to any evidence of reliance. Moreover, EPA's interpretation of what is required to demonstrate disproportionate economic hardship harmonizes EPA's statutory interpretation and its analysis of the RIN market, specifically RIN cost pass-through and RIN discount. Turning first to retroactivity.
Mr. Hughes, if we can start with the statutory argument. So EPA essentially equates disproportionate economic hardship with compliance costs.
I disagree with that, Your Honor.
Okay.
Everyone agrees that the hardship must be caused by compliance with the RFS program. The way EPA has implemented that requirement is by requiring a small refinery to demonstrate that it is paying disproportionate compliance costs. And this dates back to the 2011 DOE study. And it's important to look back at that study to understand the origin, which is an assumption underlying that study was that large integrated refiners could generate RINs for free by blending, and that small refineries that needed to purchase RINs would thereby be paying disproportionate amounts for those RINs. And so it is only by paying disproportionate compliance costs that a refinery, in fact, could have hardship caused.
Taken out most of what would be disproportionate is taken out by the EPA's assumption that RINs can be purchased ratably, and that there's RIN pass-through, right? So, what's disproportionate beyond that?
So certainly, Your Honor, the EPA's analysis of the market and of RIN pass-through and RIN discount is what is driving the way EPA is implementing the statute here. And so, EPA has to implement its requirement that RFS compliance be a cause of the hardship. And the way it does that is by requiring a demonstration that, in fact, they are not able to pass through their costs. And if they do that, then it needs to be of a sufficient magnitude to warrant the exemption. And so the compliance cost, the disproportionate compliance cost is really just a way to isolate whether or not there's any causation at all. EPA has determined that there isn't because of RIN cost pass-through and RIN discount. And so
How
in that—
could they ever prove that under your theory? Yeah. Could you give me an example of how that could be done?
I think Mr. Harrison is going to address the specifics of RIN cost pass-through and RIN discount, but they would need to demonstrate that they are paying, that they are not able to pass on their RIN costs, potentially by contracts or evidence of sales, and then
I
show.
just don't understand how that would work because like a gas price isn't broken down into the RIN component and the rest. And there are all kinds of different reasons why gas prices move.
That's true, Your Honor, but it's my understanding that you can look at RIN prices for the day. So so for instance, when EPA was demonstrating that RIN cost pass-through in fact exists, it would look at the cost of RINs, the cost of an obligated fuel, and the cost of an unobligated fuel that day. So a jet fuel or an exported fuel and a fuel for the transportation market. And so you can see that the delta between the
Triangulate.
Yeah, you could see that the difference between the obligated and the unobligated fuel was the RIN cost.
If I could ask you about this, it seems to me that a key part of your theory is that everybody agrees that it has to be a cost of compliance in order to qualify for economic hardship. But a key part of your theory is that only ratable RINs, I'm sorry, I'm going to say ratable instead of ratable, ratable RINs can be counted. And you say that using non-ratable RINs is a business decision. So that does not strike me as obvious because it just seems to me a timing issue. It's still a cost of compliance. It's just at a different time.
So Mr. Harrison is going to address that issue, but I can quickly explain. So the discount applies regardless of whenever the RINs are purchased, because the value of the RIN is recovered at the time the small refinery purchases or sells the gallon of fuel. To the extent the RIN price changes over some period of time, it could go up, it could go down. The amount recovered may be more than the RIN, more than at the time of the sale of fuel, or it could be less. And so RIN discount always applies. The question about a business decision is, to the extent that, for instance, a small refinery gambles on receiving an exemption and waits until there's a denial in order to purchase its RINs, it may be, again, that the RIN price has gone up in that time. But that is a business decision.
It's still a cost of compliance, though. They still have to buy RINs. So let me give you an analogy. If I go on a business trip and the travel is reimbursable, only the travel expenses are reimbursable, and I choose to take a flight that's better for my schedule, but that costs more, it's still reimbursable. It's more expensive, but it's not like a business decision that I've chosen this different flight. It's still it's still a travel expense. And buying RINs is still a cost of compliance, whether I buy them ratably or not. I have to buy the RINs to comply with the RFS program.
And so I don't want to, my colleague, Mr. Harrison, is better positioned, I think, to answer these questions. But I think the question is, EPA wants to prevent gamesmanship of RIN purchases. And so that's what this element of the analysis
You call it gamesmanship, but there are business reasons why people time their RINs. It's not gamesmanship to try to run your business in a way that you don't go out of business because you're buying RINs.
That's true, Your Honor. But I think, Judge Pillard said earlier that, explained correctly, that EPA's position is not that the refineries have to purchase RINs the moment they sell a gallon of fuel, but regular purchasing. And so, to the extent that EPA tells these refineries they should plan for compliance and they should not plan on an exemption. And so, to the extent that they are indeed planning on an exemption, and then the denial causes the cost of fuel the cost of the RIN to rise, that is gamesmanship.
So
what
if they're not able to buy RINs ratably, if we agree with that, what does that do to your construct?
I think I'd like to leave that question to Mr.
Mr. That's very, when I asked you a question about the statute, you said, well, our economic theory really governs our statutory interpretation. And when we ask about the economic theory, you say that's for that's for my colleague. So, obviously these questions are related, and EPA has said they are related, that the reasonableness of the economic theory drives the statutory interpretation.
Absolutely, Your Honor. That's correct. And so I think, yes. And so what my statutory interpretation point is that EPA and the refineries agree that RFS compliance must be the cause, and EPA implements that.
So let's focus on the statute then, if you don't want to talk about the economic theory. After the initial period of the exemption, EPA has to look at the DOE study and other economic factors. And I'm wondering how your theory of who gets the exemption, doesn't that just read out other economic factors? It focuses purely on this very narrow understanding of compliance costs, it seems to me.
So
any other economic factors, such as, EPA delaying in setting the amount of renewable fuel, or in, adjudicating exemption petitions, all of these factors, plus the RIN market in general, we don't think about any of those things in granting an exemption. But Congress provided for other economic factors. So how does EPA's statutory interpretation account for that?
Absolutely, Your Honor. So with respect to other economic factors in particular, EPA does look at other economic factors, including all the materials that petitioners submit, the RIN market data, transactions, and all material relevant to whether they are paying disproportionate costs of compliance. And I think that what's important to disentangle here.
What are you doing with that information? Because you've said that there are no basically disproportionate costs because of your economic theory that there's RIN pass through and RINs can be purchased ratably.
Well, petitioners are free to try to show in their particular circumstances that the economic theory does not apply to them, and that in fact it doesn't apply to them to such an extent.
You sort of defined it in a way that it's almost impossible for them to prove that. How are they supposed to show that? Like, if they've made a decision not to purchase ratably, you say that doesn't matter. EPA says that doesn't matter.
I think what we're saying is that to the extent that there is an attempt to purchase RINs, long after the time, purchase RINs close to the compliance deadline and the price of RINs has gone up, that is a business decision. But I think, what they can show or what they can attempt to show is that during the time they were selling the fuel, they weren't recovering the cost of the RINs. They weren't recovering the cost of the RINs to such an extent that it would impose a disproportionate economic hardship on them.
Let me try to ask you a question isolated to the statutory reading. If you put aside the RIN pass-through principle, just as a matter of pure statutory interpretation, is it your position that a small refinery that is facing proportionate compliance costs cannot experience disproportionate economic hardship?
And to make sure I understand the question, it's because
So let's say there's a compliance cost per gallon of fuel that's $1 per gallon. And everybody, large, small, all the refineries pay the same cost. Is it your position that your statutory reading means that even though a small refinery might find it harder, just like a flat tax hits poor people, this example in Friend's brief, flat tax hits poor people harder than wealthy people, that could be seen as hardship, or it could be seen as, hey, it's their fault for being poor, the other circumstances that contribute to their poverty, and therefore not a problem. Which is it from EPA's perspective?
So from EPA's perspective, I think I would quibble with the premise, which is that that the small refineries or the larger refineries are paying compliance costs.
Any cost. I understand. That's why I'm trying to isolate this and just to get it. And right. So if there were compliance costs that were proportionate, there are different ways to read it. I take you sometimes to be saying that the compliance costs have to be disproportionate, but I'm not sure how that's supported by the statute. If the compliance costs are proportionate, the hardship is what's supposed to be disproportionate. So wouldn't it be at least conceivable? I know this is not the world in which EPA's denial actions are operating, but to isolate the statutory question, it's conceivable that the proportionate economic costs could be disproportionately difficult for a smaller refinery to bear, and that were that situation before EPA, it would either consider those as disproportionate economic costs or say, no, everything that the small refinery brings to the table is irrelevant because it isn't caused by the RFS program.
One quick point at the outset, which is that the disproportionate compliance cost point is merely a way for EPA to determine whether there's any causation at all. I understand that we're operating in a different world, so proportionate compliance costs, I think that it could be true that if there was a $1 cost per gallon, it could affect a small refinery more than a large refinery. I think what disproportionate is getting at, which comes from the 2011 DOE study, is the difference between an assumption that large refineries can generate RINs for free versus.
Well, putting that aside and assuming, the RIN markup or the discount, I'm putting aside all of that and, perhaps assuming the rateability assumption is flawed or something, but in a situation, and you said the disproportionate compliance cost requirement is getting at causation, but I don't follow that. If one had proportionate compliance costs and one were a small refinery operating at the edge, then it could be dual causation that you could get by without the compliance costs, but the compliance cost would be a cause. They wouldn't be the sole cause. They would be a cause of a disproportionate economic hardship. But I take your position to be no, that the EPA is saying that it has to be the sole cause, and therefore it has to be that the compliance cost itself is disproportionate. Is that correct in terms of a statutory reading?
So I don't think it's quite correct, Your Honor. And I think I think you're asking a question about, okay, if every refiner pays the same amount per volume, and it's an actual cost and not the actual, not RIN cost pass through and RIN discount don't apply, then could it be disproportionate? And I think it's possible. I don't think EPA has looked at it that way because the RIN market analysis is really driving the point. And
so that, go ahead, finish your.
I was just going to say, to put a finer point on the disproportionate compliance costs is driving causation. The question is small refineries, the assumption underlying the 2011 DOE study was that small refineries are paying disproportionate compliance costs because they buy RINs, they can't pass that cost on, and large refineries are generating RINs for free because they're blending.
That was one of the assumptions. It seems like there was a whole mishmash of assumptions of what could cause hardship.
I think that was a key assumption in terms of how DOE was evaluating.
Yeah, but your reaction to my, let me just follow up one question.
Okay.
Your reaction to my question confirms something that I was discussing with Mr. Houston, which is, it seems like this question of whether compliance costs have to be a cause or the sole cause, it actually isn't really presented in this case because, as you've sort of acknowledged, it doesn't matter to this denial action. The core of the denial action is actually that the compliance costs are zero. And therefore, if you're wrong about that, you're wrong, you lose. And if you're right about that, again, it doesn't matter how we read the statute.
I think that's correct, Your Honor, because if we are incorrect about our analysis of the RIN market and the way it applies, as again my colleague will address, then I think that would be a ground for vacatur. And I think that to the extent that we are correct, then there is no hardship whatsoever from compliance.
Well,
But if
we
go ahead.
Yeah.
I was going to say, but if you're wrong in your economic assumptions, would you change your statutory interpretation?
I think we would have to see how that, in what way it was determined. We were wrong. I mean, it is, our economic analysis is, really driving the way that the statutory interpretation is implemented.
So, I mean, what is the basis for the statutory interpretation if the economic theory is held by this court to be unreasonable?
I'm sorry, what?
I mean, could you at all? I mean, to Judge Pan's questions, the same questions. I mean, how would you even support the statutory reading without the underlying economic theories?
I think our statutory interpretation would still be that, they have to show a direct causal link between the cost of the compliance and the hardship that they're claiming. I think the second part, that they have to reconcile that with RIN cost pass-through, I think depends on how the court evaluates our RIN cost pass-through and RIN discount analysis.
Is it your position as a matter of statutory interpretation that the statute does not authorize you to consider the costs of purchasing RINs non-ratably in assessing whether a refinery experiences disproportionate economic hardship?
So I think it's our position that, again, I want to leave that question to Mr. Harrison, but I think our position is that, to the extent that there is, that petitioners are making a business decision in order to purchase RINs, gambling on an exemption, and then purchasing the RINs close to the time when they get a denial, that would not be, as a statutory matter, that would not be.
What if it weren't gambling on a denial, but a hurricane hits the refinery and it has limited cash flow and it decides to carry over a deficit to the next year so that it can use its cash flow to get up and running again? Is that, and in the next year when it's carried over the deficit, happens for reasons that are not part of a group waiting for a exemption that never comes, but just, maybe there were a lot of hurricanes. Under EPA's new approach, no hardship relief for that refinery.
I think we haven't seen that approach, Your Honor. I think, it's not something we've been presented with. I think, it's
is it your statutory interpretation seems to assume the hurricane would have hit the refinery either way. So it is not caused by the cost of compliance.
So certainly, EPA can't grant an exemption to relieve the hardship caused by the hurricane. I think Mr. Houston gave an example of a tornado. To say that in either case, given EPA can't say, well, paying this amount would be difficult because you used all this money to pay for the hurricane. Because it's analogous to a sales tax where the party is recovering the tax at the time they're selling the item, and then to the extent they use that money for some other capital expenditure, and then they don't have money to pay at the time the sales tax is due. They had the money, they were able to do it, but they chose not to do so.
So I just want to make sure I'm clear on this. If we think that your economic theory is flawed and we want to remand on that basis, you would say that we should not address the statutory interpretation issue because you say that your statutory interpretation is driven by your economic theory. Is that correct?
So I want to just distinguish 2 points quickly. To the extent the interpretation is that compliance costs must be the cause of the hardship, I think that and similarly that EPA cannot use the exemption in order to relieve other hardships.
The sole cost. It must be the sole cost.
Yes.
I think so. What I would say is that it has to be a significant cause, right? It has to be a cause. It has to be of sufficient magnitude that it warrants the exemption. Because
Well, you say they can't use the exemption to relieve other hardships. Then you're really saying, if you say that the compliance cost has to be a significant cause, that they can use the exemption a little bit to relieve other hardships. And it has to be one or the other.
I think the point is that you could imagine that. Imagine, for example, that the petitioners have demonstrated they can't pass on some of their compliance costs. It's a little bit, but it's some. And EPA says, well, that's true, but you had this hurricane, and that's a really big cost. Your cost of compliance is pretty low, but this is a serious hardship, and so we're going to allow you to use. We're going to grant you the exemption in order to relieve that hardship. That's impermissible. I think if
impermissible.
That would be impermissible. Yes. To the extent that there was a significant cost of compliance, then I think EPA hasn't gone to this point because no petitioner, in our view, demonstrated that they could not pass on their compliance costs. And so, this need to be worked out in the event that, in fact, a petitioner did make such a demonstration. But, evaluating the hardship would need to be adjudicated. Petitioner, would need to be adjudicated on a case-by-case basis in that instance.
So my question.
Yes, exactly. Returning to your question, I think we would say that it has to be the cause and it has to be a significant cause, are certainly central.
But would you rethink that if we just say hypothetically, we just completely disagree with your pass-through theory that we don't think that that's supported by the record or by sufficient evidence. We think it's arbitrary, capricious, it's wrong, and we want to vacate on that basis. Would you say that we should not address the statutory construction issue because you just said that your statutory construction issue is driven by your economic analysis? So if we find that economic analysis is wrong and needs to be reconsidered, would you be reconsidering your statutory construction theory, and therefore we should not address it, just remand on the other theory?
I want to distinguish the statutory construction and the statutory implementation. So that it must be a cause, that it must be a significant cause. That's our statutory interpretation, and I think we would stick to that. The way that it's
so that's not driven by your economic theory?
What is driven by that's driven by our statutory analysis that it has to be caused by the cost of compliance from 09 A and B, and the way that this exemption works and extends it. What is driven by our economic analysis is the way that's implemented, that they have to show a disproportionate compliance cost, that is, that they can't pass on their RIN costs, and that those compliance costs have.
And it would still have to be the sole cause, though, in your view.
I think it has to be a significant cause.
Sorry?
It has to be a significant cause, all right? I mean, if, to the extent that,
But I'm sorry, sole and significant are two different things.
I agree.
It has to be the sole cause?
I think it has to be a significant cause. So to the
So it
extent,
doesn't have to be the sole cause as long as it's significant.
I think it has to be sufficient to warrant the exemption. And then at the point that, you know, EPA will then evaluate the hardship that is being experienced.
So
EPA had,
if, let's just say the RIN market goes crazy and it's very expensive and it's therefore taking a bigger toll on the smaller refineries, you would consider that?
if the RIN market, if the
It goes
cost
crazy,
by,
now there's 1,000 times the price of the normal RIN cost.
and they can't,
And that hits small refineries harder than large refineries. You would consider that?
and they can't pass on the cost. In
Yes.
this, I think we would in the event that they cannot pass on the
Okay.
cost.
So it doesn't have to be the sole cause then, in that implementation?
I think in that case,
That's also taken into account that they're small. And then therefore it hits them harder. That's not,
I think that in your hypothetical, we would consider
okay,
those
so it
factors.
doesn't have to be the sole cause.
Yeah.
I have a question about, you said you were also going to talk about the retroactivity?
Yes.
So EPA announced these proposed denials in December 2021. And a cornerstone of EPA's position is that the refineries, the default is the refineries really have to purchase RINs ratably. And in December 2021, it was impossible for any refinery to purchase RINs ratably for the compliance years in question, right?
If they had not done
If
so.
they had not already done so. And so at that point, the refineries that have not already done so were no longer able to pass the RIN costs on to their customers.
So they would still pass the RIN costs on to their customers because when they sold a gallon of obligated fuel, they would recover the RIN cost of that day.
Of that day.
Of that day, yes.
But later, if RIN costs are up.
If RIN costs are up, they would not.
I'm talking about the refiner. So your view is the refiner who hasn't purchased ratably is not going to be able to necessarily, they may luck out, they may do better, but they may also do worse and end up with costs. And it's your view that that's not retroactive because the refiners were on notice that ratable RIN purchases were inherent in this statute and regulation?
So they were on notice that they should plan for compliance at the time they were selling the fuel. So this is not retroactive because it doesn't attach new liabilities to completed transactions. They had an obligation, their liabilities accrue at the time they sell a gallon of obligated fuel.
And where is it clear before these denial actions that they needed to plan for compliance at the time they sell the fuel?
At the time they sell the fuel, I'm not sure that there's a particular citation for the proposition that they needed to purchase RINs in any particular way. At the time in the 2019 year, the 2020 year, I think they knew they had to plan for compliance and that the RIN cost can vary over the course of that year.
And EPA had no template for how they could do that costlessly, and no template that they had communicated to the refineries. Here's how, we've got this whole theory about costless compliance, provided you act in a certain way, right? I mean, EPA doesn't dispute that if you don't act in a certain way, purchasing ratably, that sure, you can have either compliance costs or compliance bonanza, depending on what your particular choices were, right?
Well,
Maybe this gets into.
No, I think
comparisons.
there are, there were the RIN cost pass-through and RIN discount theories were articulated several times over the years in the 2015 Burkholder memo, in the point of obligation denial, in the Ergon
even back in
cases.
2009, but then that was superseded by the 2011 DOE.
Yes, I don't think that the 2009 DOE study addressed RIN cost pass-through exactly. I think it assumed that the cost of compliance would not be significant for small refineries versus large integrated refiners.
So you'd say that they were on notice about RIN cost pass-through. Were they on notice about the logic of ratable RIN purchases? And where?
I'm not aware, perhaps Mr. Harrison is aware of a citation in the record for that. I am not, I think.
I just have one more statutory question. So you say that if we were to decide on the arbitrary and capricious grounds, EPA would stay with its statutory interpretation, its primary statutory interpretation.
That RFS compliance has to be.
So let me just ask you.
Finish the sentence, that RFS compliance.
RFS compliance must be a cause of the hardship, and it must be a significant cause.
Compliance costs.
Compliance costs.
Right. So, I mean, in the statute, it says that, in considering whether to extend an exemption, right, the EPA has to consider the findings of the DOE study and other economic factors. And in the previous section, I remember the exception, right, the DOE study is based on compliance costs. And then in this section, it says DOE study plus other economic factors. So if EPA's position is that it can only be compliance costs, I mean, that just seems to be inconsistent with the text of the statute.
Well, the DOE study is from 2011, and so EPA can't rely entirely on that study in order to make a determination as to whether a refinery today is experiencing disproportionate compliance costs. It's going to take into account.
Oh, and remember, the statute is disproportionate economic hardship. Hardship
Yes.
is not the same as costs.
So EPA can't look and determine whether there are disproportionate economic hardship based solely on the 2011 study. And this court in Hermes has said that EPA has broad discretion in determining what economic factors to consider, and that this broad language evinces a intention just not to tie the agency's hands in terms of what economic factors.
Right. Well, that's a sort of a broadening interpretation. The agency has discretion to consider a range of factors, but what EPA has said is really there's only one factor, namely compliance costs.
Well, I think it's looking at a range. Certainly the compliance cost is structuring, the RIN cost pass-through and the RIN discount is structuring the types of the types of factors that it's looking at. But I don't understand Hermes to be saying that EPA can only extend the universe of factors it considers. It can reasonably restrict in order to effectuate the purposes of the statute as it sees.
Thank you.
Thank you.
Good morning, Your Honors. Brian Harrison, also on behalf of EPA. Judge Pan, you asked a question to Mr. Houston, what would happen if the petitioners were to lose and then had to buy RINs here? And the answer to that question is nothing. And the reason is that the petitioners here don't have to buy RINs at all, because except for two of the petitioners, every single one of them in this case has retired every single RIN obligation necessary to comply with all of their RFS obligations at issue here. And for the other two petitioners, EPA considers them in compliance while their stays remain pending.
But what if they lose and the stays are not pending?
As to those two other petitioners,
Yeah.
well, as it's been demonstrated, EPA provides compliance flexibilities through a variety of means. And so there are certainly options that EPA could explore with those petitioners and how to address those issues. I'd like to, so I'll be addressing the reasonableness of EPA's action and also the eligibility question, issues 4 and 5 of EPA's brief. The denial actions are reasonable and appropriate under the Clean Air Act. EPA grounded its decisions in extensive data and analysis in the record. It considered all relevant factors and articulated a rational connection between the facts found and the denial actions themselves. And its decision should be afforded significant deference here. This court should not second guess EPA's decisions as petitioners have suggested that we do. There's been a lot of talk today about the RIN discount and the RIN cost pass-through, which are EPA's fundamental economic principles that form the foundation of its decision here. There's also been some talk about the genesis of those and where they came from. Judge Pillard, as you mentioned, in the 2009 EPA study, there was discussion about the discussion of the RIN discount and RIN cost pass-through principles generally, but it was more fully developed in the 2015 Burkholder memo by EPA, which formed the basis for the 2017 point of obligation denial, which this court affirmed in the Elan decision, where 13 of the original petitioners here were also petitioners in that case, and where this court found that EPA had reasonably explained and justified its basis for not only the point of obligation denial, but the RIN discount and RIN cost pass-through principles. But here, what EPA has done is they've taken that and built upon it. They've used additional market data. They've revised the information that they've had. They've used their decade plus of expertise in administering the RFS program. And most importantly, they took information provided to them by the small refineries themselves and by market participants in order to confirm the applicability of the RIN discount and the RIN cost pass-through principles here. After that, EPA issued a proposed denial and invited the small refineries to come forward with information disproving the applicability of those principles to the specific small refineries. Many of them took EPA up on that opportunity, and EPA evaluated carefully each of the small refineries' submittals, both as proposed comments and also supplements to their small refinery exemption petitions. And what EPA found when it did that analysis was one of two things. One, there was either insufficient evidence to disprove the applicability of the RIN discount or RIN cost pass-through specific to that small refinery, or in many instances, the second point, many of those small refineries submitted information that supported EPA's economic principles of the RIN discount and the RIN cost pass-through. For example, in at least 4 of the petitioning small refineries provided pricing contracts that demonstrated the existence of the RIN discount principles. In response to that, what EPA or what the petitioners have provided here is said, EPA, you were wrong, we were right. But petitioners need to do more than that here. And as we cited in our brief, and the Supreme Court has long recognized, the burden of proving an exemption under a special exception to a statute rests with the party seeking the exemption.
What about their argument that they can't buy RINs ratably all the time because they're small refineries, RINs are sold in larger batches than they can do. So they only can do it 1 or 2 or 3 times a year, so they can't do it ratably. And then you say you can't even apply for a economic hardship exemption if you're not buying them ratably, because that's therefore not the sole cause.
So, Japan, I would like to, I disagree with the premise there that the ability to purchase ratably is linked to the EPA's RIN cost pass-through. These are distinct concepts because in the application of the RIN cost pass-through, if I'm selling you a gallon of fuel for the fuel costs 99 cents and the RIN costs 1 cent, the second you give me that dollar, I have the 1 cent for the price of the RIN that I can then go out on the market and buy. The question that you're asking, though, goes to the second point on the ability of the small refineries to ratably purchase those RINs when I have that 1 cent in my hand. And I think to that, there were a few petitioners who provided general comments that they had challenges or issues with purchasing RINs on such a small scale. EPA, in its experience and expertise in administering this program, responded to those comments, specifically in confidential appendices to the 2 that did, and also in Appendix B generally, that there exists RIN brokerages and other publicly available ways for them to acquire those RINs. And one other point on the ratable purchases that Judge Pillard...
That doesn't really answer my question. My question is, if they are not able to purchase RINs ratably, then you won't even accept their hardship petition because you're saying, oh, you made a business decision. The RIN compliance is not the sole causation.
Well, and not necessarily, Your Honor. And the reason is because there's a possibility that if this small refinery did not purchase RINs ratably and the cost of the RINs are lower at a later point in time when they acquire them, then they have no hardship there because they received the benefit of receiving more for the RIN. And
so in the situation, let's make it a hypothetical. Say they can't purchase RINs ratably and they have a hardship because RIN prices have now gone through the roof and they want to tell you, now I have an economic hardship. You wouldn't even accept that because you're saying that even though you're buying RINs, which is complying with the RFS program, that's not a cost of compliance because of the timing of which they did that.
Right. And so I think, so for one, that's not what we have here. No petitioners have
Can you
provided.
just answer my
But
hypothetical?
so for that hypothetical, I think the answer is that if that information was demonstrated to EPA, then I think that would form a basis for EPA to then consider a small refinery exemption petition.
Oh, so you're walking back then that it's a business decision if you buy.
Well, then, I'm sorry,
Ratably.
I may have misunderstood your question then. I think the point that I'm making is that the EPA believes that petitioners and small refineries can purchase RINs ratably. In the event that they're not able to, and the costs of the RINs have gone up significantly, EPA's position is still that was a business decision that they made by not purchasing the RINs on a ratable and ongoing basis.
Okay, so then can you answer my question? Why is that not a cost of complying with the RFS program? They're still buying RINs to comply with the program. This is just a timing issue when they buy the RINs.
Well, it's because they have assuming you're outside of the construct of your hypothetical, they have the money in their hand at the time that the transportation fuel is sold. So they're able to go out into
They're able to, but they've chosen to comply with your program in a different way. It's still a cost of compliance with your program.
It is, but again, I think.
If it is, then they should be able to make that application to you.
But it's a business decision. And so as Mr. Hughes mentioned.
If you could address my hypothetical, which I gave, I guess, to the wrong attorney. If I go on a business trip and my travel costs are covered and I order an Uber and I could go an hour earlier or I can go an hour later and it'll be surge pricing. Okay. And I pay more because I go an hour later because it's more convenient for me. I still get reimbursed for my Uber, even if I choose to do it at a different time that costs more. It's still a travel cost. How is this any different?
It's different because it applies across the board to all obligated parties. And so.
That doesn't make it different.
Well, I think that it does in this circumstance, right? Because other obligated parties retire RINs on a ratable basis and don't experience the ongoing claim hardship.
My question is, why does it even matter? It's still a cost of complying with your program, no matter what timing I put to this.
I mean,
if you could just answer, Judge Pillard.
Yeah.
I think my answer is the same. The cost of the compliance is based on EPA's expectation that the refineries will retire the RINs in a manner that is, however they choose, but if they do it ratably, which is a good business practice that EPA has said is that, then the costs of compliance are not as disproportionate as they may be in a future situation where the RIN prices go up.
So, I mean, I take it what you're effectively saying in response to Judge Pan is, no, it's as if there were also a rule at your company that you can't, that you have to buy more than 2 weeks in advance your airline ticket. If there's surge pricing, you have to take the metro, or, that you're really imposing an additional requirement of reasonableness of the recovery of the travel costs.
Well, so to that point, I think if there isn't that level of reasonableness or whatever you want to call it, then what happens is that the small refineries will then game the system and attempt to wait to the end of the year in the hopes that the price of the RINs is down, or that they could receive an exemption.
But the bottom line is you have to make it not a travel cost in order for the statute not to apply. It has to not be a cost of compliance.
So I have other questions, even assuming your ratability concept in principle is consistent with the statute and would resolve a lot of the problems with the fluctuating RIN market. And first and foremost, as Mr. Houston mentioned, in 2019, the EPA analyzed a proposal to require real-time, and then it said that would be a little quarterly RIN compliance submissions, retirements. And in that context, and I found this really revealing, EPA concluded it would be, quote, virtually impossible, close quote, to require ratable RIN retirement. And it wasn't about, bureaucratic burdens having to do with the actual retirement. Had to do with the acquisition. The generation of, this is a quote from 48 Fed Reg at 10.616. The generation of RINs and the production and import of transportation fuel are not aligned over the course of the year. Cumulative RIN generation would not catch up to the cumulative RIN retirement requirement until December. Now, as I understood this when I read this, basically the blending is not, auspiciously done all along throughout the year. Cold weather affects it. Very hot weather may affect it. And so in practice, blenders are not actually generating RINs ratably. And so if all refineries thought, I'm going to do just what EPA says, and even if it was only weekly, I'm going to just do it as I go along. I take EPA's factual position in 2019 to have been, that cannot be done, at least not by everybody. And I don't see an answer to that in the denial act.
EPA did address this, what I think they've called RIN hoarding by the blenders in Appendix B to the denial action itself, and found that there's no evidence to suggest that blenders are withholding supplying RINs to the market for parties to.
I'm referring to RIN hoarding. I'm not referring to anything that has to do with trying to play a market, beat a market, corner a market, manipulate a market. I'm just referring to the actual physical engineering that takes place as EPA described it in 2019. And as I understood that description, it was saying, if you're a blender and you're in business to blend for good reasons that have to do with temperature and the process that you're engaged in, and plus a little bit the demands of for RINs, that, big uptick at the end of the compliance year, that they're not blending evenly throughout the year. And if they're not blending evenly throughout the year, and you tell the refiners, you got to be buying ratably, they are not going to be able to do that unless there's something I'm missing, and I didn't see it.
So I don't think that
In the
EPA, so with respect to the denial actions, I don't think that was directly addressed beyond the point I mentioned about the RIN hoarding. But further to that point, I think it's important to note that EPA has invited the small refineries to come forward with specific information like that the blenders are not providing them with the RINs because they're holding back for seasonal allocations and things like that. And EPA just hasn't seen that here.
Well, EPA described it. And also in the NITEL study, the 2017 study, which I thought was really, really clear and really helpful, EPA relies on that study. And then EPA basically says, look, you can insulate yourselves, small refiners, from the vicissitudes of the RIN market by effectively taking that penny price premium that you got when you sold the fuel and turn around that day and buy a RIN, right?
Well, it doesn't have to be that day, but
okay. In fact, if it were that day, you would lose out, because the NITEL study says 100% recovery really doesn't happen until 2 days later, right? So really your rule should have been buy ratably, asterisk, meaning 2 days later.
So the rule that was discussed, or that we're discussing, was never finalized by EPA on the ratable purchases.
No, but it was information that was published that presumably is factually accurate about the world.
And so I think this goes to the point you made earlier, Judge Pillard, about the ratable purchasing doesn't have to be immediate or real time. It's on an ongoing basis, whether it be daily or 2 days later or a week later or a month later. At the end of the day, the ratable purchasing is on an ongoing systemic basis, and sometimes it'll be high and sometimes it'll be low. But at the end of the day, what EPA's found is that it balances itself out.
That is a surprise to me. What is ratability? And if EPA doesn't give a clear definition of what it is, and then say that definition is supported by the economic data on which we rely, then I don't think it's connected the dots. I mean, I do appreciate I appreciate the role that the ratable purchasing is as a kind of saying, look, guys, this is the pass-through is in general and in the aggregate. To make it come home for you, you also need to behave reasonably, right? I mean, that's EPA's position. Here's how you behave reasonably. And I don't think EPA has clearly said, here's how you behave reasonably. And if it's monthly, there's still a lot of exposure to the RIN market, or EPA hasn't endeavored to say, here's why there's not a lot of exposure to the RIN market. And that is actually what we mean. If you do it monthly, that for us counts. Or if you do it weekly, that for us counts. I mean, even the weekend holiday problem opens an aperture of exposure to a market, right?
So in response to that and generally, the weekend issue EPA reviewed and analyzed and found there to be no significant correlation between having the weekends exist and having weekend pricing as well. And that goes to the larger point about all of this is that if this is not an issue, then the weekend pricing is not an issue unique to small refineries. It's unique to all it's common to all obligated parties. And
But the weekend pricing issue does undermine your theory of pass-through and discount. And it seems to me that the answer that in the long run, this all evens out doesn't really address the problem because these applications are not in the long run, they're by the year. And I just think that that's a significant flaw in your reasoning on the pass-through and the discount theories.
Well, so EPA responded specifically to the analysis provided about the weekends and holiday rates and explained why that was wrong. And then also. And
the explanation was you should buy on Friday.
Or market participants could make purchases on Friday to account for the weekend. They could purchase on enter a contract to purchase on Monday with the estimated sales. And then there could be a difference, a sale to cover the difference. EPA articulated a number of ways that that a small refinery could go about doing that.
So do your best to explain what you think you mean by saying small refineries must purchase ratably.
Small refineries must purchase RINs on an ongoing and systemic basis in a manner on a regular, which is usually a regular basis, in a manner that acquires as many RINs as possible, as close to the time that they acquired the cost of the RIN from their sale of transportation fuel.
Take a step back and just ask you, when Congress created this system, it realized that there would be a market for RINs. It created a market-based system for the buying and selling, that EPA would administer. And it seems that now EPA's new assumption is that this market is basically perfectly efficient, that there is pass-through, that, that the market functions in this particular way. But it seems like a key assumption that Congress made in enacting the statute was that even in a market-based system, there could be, disproportionate economic hardship for small refineries because of their unique circumstances, even in the context of a market-based system. And I'm just wondering how EPA's general conclusion that there's sort of perfect market efficiency is consistent with what Congress seems to have assumed in enacting the statute.
Sure. So a few points on that. One is that Congress left to EPA the implementation of the RFS program. And so EPA has developed that expertise and experience over the course of administering the program to better understand how the small refinery exemption best applies and best fits in with the purposes of the statute and of its regulatory purpose. And I think also.
It seems like over time means over time EPA has concluded that this market works efficiently and in some kind of perfect way.
Well, so that is what.
Even for small refineries, even like sort of aggregated across the market. And that seems to be in tension with the statute.
Well, so EPA studied the RIN discount and RIN cost pass-throughs here specific to the small refineries with information provided to it from the small refineries on market data, on pricing and other information. And it found that the RIN discount and the RIN cost pass-through principles applied. EPA then went back to those small refineries and said, give us information that shows that we're wrong and that that these don't apply to you. And in every instance, EPA analyzed and studied that information and found that the RIN discount and the RIN cost pass-through principles apply to that specific small refinery. Or, as I mentioned before, in some circumstances, found that the information was either not sufficient to support the invalidity of it or directly supported EPA's position on the RIN discount or RIN cost pass-through.
That's because, I mean, EPA seems to, it describes facts in the world as, to Judge Pillard's point, well, what if blenders aren't producing RINs? You say like, well, that's not, there's RIN hoarding or there's gamesmanship by small refineries. But some of these actions may just be part of, how small refineries do business.
Well, so I guess 2 points on that. One is that
Like, it doesn't have to be gamesmanship for it to be economically rational for them to wait to purchase RINs.
right. I think
And it doesn't have to be RIN hoarding if a blender isn't able to, produce RINs on an ongoing basis.
right. I think that the important thing to note on that is that the petitioners have not provided the information. EPA has said, and EPA certainly would see that there are likely circumstances or variabilities that may come up that would be sufficient to prove disproportionate economic hardship or to justify a small refinery exemption. But under the facts presented here and in the record that we have here, no small refinery has done that. And so to your point, Judge Rao, about whether the way that EPA is implementing this is effectively reading the exemption out of the statute, we disagree with that. And we've explained in our brief how there are things that the petitioner's small refinery can submit to EPA. And if those are submitted, EPA will take a look at them, and perhaps those rise to the level sufficient to justify a small refinery exemption.
Seems very unlikely.
So I think you mentioned in response to a question from Judge Pan, or it might have been your colleague, that all of the small refiners before the court have actually made their compliance showings for the 2019 to 2021?
That's correct.
But did they do so ratably? I mean, did they, not the showing, did they buy the RINs? They bought the RINs presumably non-ratably, and so they're pointing to costs, and EPA is disallowing those costs?
I don't think that there's anything in the record that shows how those RINs were acquired. So I don't want to speculate to that point.
Wouldn't you, under your definition of rateability, seems like that would be pretty challenging to implement, because you would have to look at the pattern of RIN purchases for every applicant and decide whether it was sort of, systemic and continuous enough. Is that wrong?
I don't think so, but I do think that what I want to make sure we're clear on is that there is a distinction between the ratable purchasing of RINs and the applicability and validity of the RIN cost pass-through. And so...
Right. I understand EPA to be saying, you can correct me if I'm wrong, that the RIN pass-through is shown, and that it's shown to be true on average and across time, and it's shown pretty solidly. But that the second part of your denial action is also critical from the perspective of an individual small refiner, which is, how do we make sure that we are in the average and not, high or low in terms of RIN costs? And to that, your answer is you buy them ratably, right?
You can choose to buy them ratably.
Yeah, you choose to buy them ratably. And if you do that, you'll be protected. You will be zero or trivial in terms of your compliance costs, right?
Correct.
And what I'm not seeing is a clear enough definition of what ratably means, and a demonstration that if that definition, whatever it is met, that the allocation among small refiners of the data points that make up the average of zero are actually also going to be zero or close there too.
Well, I think to that point, Judge Pillar, the key is to remember that the burden here rests with the small refineries to establish that they could not purchase, that they are not passing on their RIN costs.
But how do they even know what ratably means to show that they've done it?
Well, I don't think, well, they can show that they haven't passed their RIN costs on in any number of ways, and perhaps one of them is ratable purchasing, but
So you're saying even on this record, they haven't shown, having presumably not done it ratably, they haven't shown their net costs from in that situation.
Yes, that's correct.
I'm making a skeptical face because I'm not sure that I saw anything addressing that in the denial action.
So EPA responded to specific comments from petitioners who claimed that they were not able to purchase RINs ratably. We addressed these at pages 74 to 77 and 78 of our brief, or 79 of our brief. And
this is the contracting and broker point?
to some extent, but also that how they're not able to acquire RINs ratably for other capital reasons, for reasons of capital or other costs.
Your friend on the other side said they're unevenly generated, and they also don't know how much they're supposed to buy because the EPA doesn't timely put forth its volume requirements. What about those factors?
Well, so I think on the uneven generation of the RINs, we've touched on that a little bit. I mentioned how EPA responded to the claim that there's no evidence to support that blenders may be holding on to RINs and distributing at various times. And on the point, and what was the second point, Judge Pan?
That they don't know how much they're supposed to purchase because EPA doesn't let them know what the volume requirements are on a timely basis.
Well, so I think to that, EPA, even in those situations where EPA has acted belatedly, the compliance obligations are always following the year in which, the obligations must be demonstrated in the year following that of the compliance year. EPA has provided compliance flexibilities in a number of circumstances.
But that assumes that the compliance is the once a year retirement of the RINs. And there's a window for getting your paperwork together and showing the compliance. But if ratability really matters, then you're also saying that the small refineries should be purchasing as they go along. And to the extent they haven't been doing that, then the late announcement of the level of requirement and the compliance flexibility doesn't capture their ability or inability to make up for not having contemporaneously purchased RINs. And you're saying, well, they should have known that. Even before the denial actions, they should have known that.
Well, the default here under the statute is compliance. And so.
But you're adding a wrinkle to compliance.
Well, the way to, a procedural, the way to obtain compliance is to either acquire the RINs through purchasing or through blending.
And ratably, crucially.
Well, that is what EPA has recommended that obligated parties do as good business practice, but has not required small refineries or obligated parties to do.
If they want to get an exemption, it's required.
Well, not necessarily, Your Honor, because if
they want to get an exemption and they, by not having done ratably, they end up behind the market. I take your position to be tough luck.
Exactly.
Okay.
But on the other hand, if they wait to the end to purchase the RINs to demonstrate compliance and the prices have gone down, well, then they have more money in their pocket. So again, I just want to make sure that the ratability per point is separated apart from the RIN cost pass-through notion.
Is it? I mean, I know it's conceptually separate, but it seems like you need both to prevail.
Well, both for a small refinery.
Yeah, you don't claim that pass-through alone ensures no compliance costs for an individual refiner.
I think that's, yes. But If I may, on just two other points on the merits before addressing the eligibility question. There was a point made about a windfall of blenders and how blenders receive a windfall of profits from selling their RINs. EPA studied that as part of this denial action and found that that was not the case. And if I may just make a few quick points on eligibility. I see I'm over my time.
We'll give you 2 minutes to do that.
So on issue 5 for eligibility, EPA correctly found that the two refineries, company A and B, were ineligible to petition for the small refinery exemption because they were not small refineries at the time of the initial blanket exemption provided by 754509A. And the reason is company A was not an obligated small refinery because it produced more than 75,000 barrels per day in aggregate for the qualification years, and it retired RINs to demonstrate its compliance. And the reason company B wasn't was because it didn't produce any transportation fuels during those qualification years. EPA's interpretation that a small refinery must have received the initial blanket exemption is consistent with the Supreme Court's decision in Holly Frontier, which said, quote, "There is nothing odd about the fact that Congress chose only to protect existing small refineries rather than new entrants."
But didn't company B produce crude oil, and isn't that the trigger?
So company B made a later business decision to begin producing transportation fuel, which triggered its obligations under the RFS. Prior to that point, it was producing fuels, but non-obligated products.
So at the time that the statute that they're relying on was passed, they did not fit the definition of a small refinery, in your view?
They did not, correct. And the reason is because they were not producing the obligated fuels
So you're not relying on the fact that they didn't, I guess, do the letter to be deemed a small refinery?
Well, so that's an additional basis that we've argued that the EPA's regulations at the time in 2007 and 2010 required an entity claiming that they were eligible to receive the small refinery blanket exemption to tell EPA that they did. And the reason for that is EPA can't say, no, you're not eligible to receive the exemption, but it's EPA administering the program and issuing those regulations so it knows which refineries are claiming the small refinery exemption for that period.
EPA did give them an exemption, though, in 2018.
EPA gave both Company A and Company B exemptions in 2018, but those were remanded by this court during the pendency of the Holly Frontier decision.
One more question. Just moving forward, what exactly is EPA looking for in assessing hardship petitions going forward?
Well, I think a lot of that, Your Honor, depends on how these cases are resolved.
Assuming your denial actions are sustained.
Then what EPA, so you're asking what is EPA looking for in a small refinery exemption petition to qualify for? So we explained in our brief, I can find the quote, but we explained in the proposed denial that those things that a small refinery can provide to EPA that would help it show it things that may be sufficient to show disproportionate economic hardship under the statute.
Would be something like, we can't find a broker that will help us purchase RINs ratably. We can't find RINs for sale until later in the year because of the pattern across the calendar year of blending.
Well, so though, again, EPA received that information and analyzed it and responded to it in the record. The area of the proposed denial that outlines the various points it's on our brief, pages 95 to 96, and the JA is at 227 to 228. And so I think, again, to my point earlier to Judge Rao's questions, EPA is not foreclosing the possibility of these exemptions. They're just saying that under the record here, the specific small refinery petitioners have not met their burden to demonstrate that they qualify for the small refinery exemption.
I'm sorry, you said JA something 27 to 22?
JA 227 to 228.
Great, okay. All right.
Thank you.
Thank you. Now we will hear briefly from Mr. Morrison for 3 minutes, and then Mr. Houston has a brief. Good morning.
Good morning, Your Honor. Good morning, and may it please the court. My name is Matthew Morrison. I represent the Renewable Fuel Interveners, the Renewable Fuels Association, and Growth Energy. I'd like to make a few brief but important points to address some of the panel's questions that have arisen this morning. And I'd like to begin with addressing a point that Judge Pan made, an inquiry that Judge Pan made about what's at stake in this proceeding. For small refiners, as you've heard, the stakes are actually not very high. That's because the overwhelming evidence has confirmed after a decade of study that whatever costs they incur in complying with the RFS are costs they will recoup. And if there is any suggestion of incurring costs greater than other refiners, those costs cannot be related to RFS compliance, which are, for the most part, essentially the same nationwide. But for renewable fuel producers, this is a high-stakes proposition. The petitioners are asking this court to absolve them of responsibility for 1.63 billion gallons of renewable fuel, gallons of fuel that Congress intended to be blended into transportation fuel. So if this court grants the petitioner's wish, their exemptions will erase those volumes, devastating renewable fuel producers nationwide. It will also decrease the demand for renewable fuels, which Congress actually sought to increase through the Renewable Standard Program. And it will threaten the financial viability of America's farmers and renewable fuel producers who have seen the price for their products plummet as a result of these unwarranted exemptions.
What percentage of the market is attributable to small refineries?
I'm sorry, Your Honor?
What percentage of the market is attributable to small refineries?
I think it's depending on if you define it by the 75,000 barrel per day. I think in the DOE cutoff, I'm not sure the exact percentage. I want to say it was about a third, perhaps.
A third.
I'd have to check on that, but yeah, I'd have to check on the exact
And that's not
percentage.
the exempt.
Those are the ones that qualified for 75,000 barrels a day or less.
Those small refineries produce 30%.
I don't know the
output?
exact percentage. I don't know the exact percentage. I would be happy to look into that, but I don't have that number off the
Is
top.
that relevant to whether it affects the market?
Yes, it does. Yeah, it certainly would. Secondly, is there anything else?
That if the renewable, that there would be 1.63
Billion gallons.
billion for the
Billion with a
billion
B.
gallons of renewable fuel that would be forgiven. And are you referring to not the refiners' obligations that are subject to the alternative compliance action, because those are being deemed
It's the
met?
total
Talking
volume.
about 2019 to 2021, the obligations that EPA has left intact, but as to which it's allowed compliance flexibility?
Right, that number represents the total volume obligations of the refiners in the April and June denials.
So it doesn't.
It doesn't back out
It doesn't back out.
what they might have
The
done through an
alternative
alternative.
compliance demonstration.
That's correct, Your Honor. That's correct.
Do you have the figure for the only remaining
No, but
obligations that EPA is purporting
Not
here
for
to
the-
enforce?
not for the net difference, but that would, backing it out would only apply, of course, to the April denials. For the June denials, it would still be those volumes. They have additional time, but we're still talking about those
And
volumes
that's
at
the
risk.
amount that I'm interested in, because that really is, I mean, given the side that you've intervened on, that's the only amount that actually is at stake. It's not the part that's subject to the alternative compliance
Well, I know that's
action that's gone.
right. But that's still a relevant volume, because if those volumes are forgiven by the agency, that means there's less demand for renewable fuel in the future.
And what,
Is that right? Because I thought in 2020, EPA changed its calculation practices, and that as of 2020, if there are exempted refiners that they don't figure into the denominator for the calculation of the obligations. And so the entire amount, volume that EPA has said is feasible for the market to produce, those obligations are put on the non-exempt remaining market participants. So it's not going to have an effect under that approach on demand for renewable fuels. Is that wrong?
EPA, no, Your Honor, EPA was at one point doing a look back at the amount of small refinery exemption volumes it had provided in prior years and setting the volumes going forward. We're no longer in that period right now after beginning in 2023. But yes, the EPA did take into account, it would look at the volumes that were exempt in prior years. It did.
And you're saying that expired as of 2023?
Excuse me?
You're saying that expired as of 2023, that treatment?
In 2023, EPA gets to set the volumes based on a variety of factors laid out in the statute. It's almost like a new RFS or RFS 3. It's no longer looking to the volumes that Congress set. And that's really important because there's been a little bit of discussion today about late volumes. There's no late volumes when the volumes are set in the statute. And in the years in question we have, Congress was pretty clear about the volumes it expected.
So what is the total volume? Because we're talking about 1.6 billion gallons here. What's the total volume of renewable fuel?
What's the what?
What's the total volume of renewable fuel? I'm just trying to get a sense of the scale of this
For
issue.
those years in question, nationwide, for 2016, I apologize, I don't have the numbers. There's typically around 15 billion gallons of conventional renewable fuel, corn-based ethanol. There's a lesser amount for advanced biofuels, which could be cellulosic fuels and biodiesel. So it's in the range of 15 to 20 billion gallons.
So this is 1.6 billion.
Right, exactly.
But over a period of years, the 1.6, and you gave an annual.
Right, I'm talking annually, that's correct.
1.6 is annual? No, the 1.6 was the cumulative overall.
That was
years
just
at
what we're
issue.
talking about for the exemptions
All the years at issue.
at issue here, yeah, altogether. Secondly, I wanted to try to clarify an important thing that's come up repeatedly today about causation. To qualify for an exemption, RFS compliance obligations have to be the direct cause of the hardship, even if the refineries allege reasons unrelated to RFS compliance. In other words, the refinery has to show that the hardship would not exist but for the RFS compliance obligation. And contrary to what the petitioners have argued, the EPA has never adopted a sole cause standard here. In fact, the petitioners concede on page 50 of their brief that a but-for standard is appropriate. So things such as structural or macroeconomic conditions, even hurricanes, can contribute to the hardship, but there can be no exemption if RFS compliance costs are not a direct cause of the hardship. And to the extent that a hardship would exist for reasons entirely unrelated to RFS compliance, that should be ineligible for an exemption. And really, this is as much common sense as it is the best reading of the statute, because it would make no sense for Congress to allow relief from RFS obligations where the exemption would not even redress what was causing the hardship.
All right. Thank you.
Thank you.
Thank you, Your Honor. I'd like to begin with Refinery A just briefly. This refinery received the original exemption from Congress. Statutory text 754509A says, quote, "The requirement to comply with the RFS shall not apply to small refineries before 2011. Refinery A met the statutory definition of small before 2011. Now, EPA thinks that HollyFrontier clarified the law, but if that's right, if they're going to use the Supreme Court's clarification to adopt a new interpretation of eligibility for the exemption, they have to give us fair notice of it and apply it prospectively. On the statute, I think I heard my friend Mr. Hughes say that EPA started with a new economic theory and then let that drive its statutory interpretation. That's precisely the problem. They worked backwards to twist the text to make it fit and try to squeeze it into their new economic theory. Judge Pan, I think you have it exactly right. We agree that RFS compliance has to be a substantial contributing factor. It has to be a cause of the hardship. Our point is that the compliance does not need to be the sole cause of the hardship. A sole causation standard is incompatible with the statutory term disproportionate economic hardship. Now, my friends equivocated at the podium today about what, but the denials are clear. EPA demands disproportionate costs, not disproportionate hardship, and it insists on a sole causation standard. You can see this at JA 3224, including footnote 13. This was driven by the 10th Circuit's analysis adopting a sole causation standard. Judge Pillard's hurricane example powerfully proves why that simply makes no sense. Given that refinery's economic circumstances, in the language of the statute, it is experiencing disproportionate economic hardship from compliance with the RFS. But EPA has told us in the denial actions expressly that it would refuse to consider that economic circumstance as a basis for hardship relief.
Do you think the 10th Circuit's reasoning was wrong, or do you think EPA has mischaracterized it?
I think, honestly, it's actually a little bit of both, to be quite clear, Your Honor. I mean, I think that the 10th Circuit's reasoning is flawed because I do think the 10th Circuit says something pretty similar to what my friend Mr. Morrison said, and we just fundamentally disagree with that. We don't think that you can make the statutory standard disproportionate economic hardship work on that ground. The 10th Circuit did say it endorsed the idea, for example, refusing to consider natural disasters. I think EPA then sort of grabbed onto that reasoning and then attempted to drive a truck through it and make it do even more work, even though that opinion was obviously vacated and overturned by the Supreme Court.
It wasn't overturned by the Supreme Court.
Well, the 10th Circuit's opinion was.
Yeah, but they only reached that one.
Yes, but in response to that, the 10th Circuit.
And EPA has said we're relying on the reasoning.
Yes.
It doesn't matter whether it's authoritative or not.
Sure.
A panel of judges grappled with the issue, described their outcome, and EPA says we think that's right.
Yeah, the 10th Circuit subsequently vacated that opinion, but yes, EPA says that it was relying on its own independent conclusion. I'm happy to take them at their word on that. I think the point is just that's not consistent with the statutory text, with what disproportionate economic hardship means. On whether the EPA's reasoning is arbitrary and capricious, we've talked a lot about the flaws in their ratable RIN instruction, including their unexplained change from their prior statements. I think that's the most obvious flaw in their analysis, but it's certainly not the only one. Their conclusion is about pass-through, that it happens everywhere for every refinery all across the country. But the way that they get there is by extrapolating on just two fuels markets, the Gulf Coast and New York Harbor, and they have no plausible response to the voluminous evidence that petitioners put in the record explaining why pass-through doesn't happen always given their individual circumstances. EPA doesn't have a meaningful response to PAR Hawaii, which has to index its fuels to the Singapore market, where there obviously is no RFS. It doesn't have any plausible response to Calumet, Montana, where the market, as we've shown in a declaration, is dominated by large integrated refiners that force Calumet to discount its prices below the market standard. DOE always recognized this. It knew that when RIN prices rose and EPA demands more blending, it will be a significant advantage to blend rather than be at the market. That's exactly what happened. That's JA 1415. On retroactivity, Judge Pillard, I think you asked my friends at the EPA, where did EPA tell the refineries before this compliance year they will have no cost so long as they buy ratably? They couldn't give you an answer because they didn't. EPA said in 2017, refineries, quote, need not acquire RINs at the same time that they produce the fuel. That's JA 16,300. And of course, as you noted, they said it would be virtually impossible for the market to meet that demand. They are punishing us in December 2021 for having failed to buy ratably back in 2019 and 2020, when we had no opportunity to do anything about it. Thank you.
Thank you very much. We'll take a short break and we'll resume with 22-1074. Take 5 minutes. I mean, that's right. I think I thought this. There's a couple that's. Okay.
Stand, please. This honorable court is again in session. Be seated, please.
Good afternoon.
Good afternoon. All set? Okay, may it please the court. The premise of this case, of course.
My name is
My name is David Lane on behalf of Petitioner
Lane.
Growth Energy. Premise of our challenge is, our challenge is to the alternative compliance actions. The premise, of course, is that the denials of exemptions that were the subject of the prior case are valid. Based on the questioning, I think I need to skip a few points about EPA's discretion in this context and really focus on some of the retroactivity issues that have come up because they're central to the
Let's
AC.
first start at the threshold about jurisdiction over your petition and standing for growth energy.
Certainly. I think that standing has already been decided by this court in the Elan case and then a national biodiesel case. In both of those, petitioner was an association of renewable fuel producers challenging the level of RFS obligations. And the court found standing because RFS obligations, when you lower the obligation, you invite additional competition for the content of the fuel.
I'm aware of those cases, but so what about our recent decision in Ohio versus EPA, which found that the petitioners had not met their pleading burden for standing?
In those cases,
So it's not the case that growth energy, even if it's been granted standing in the past, sort of perpetually has standing to bring claims. In every case or controversy, they have to meet the pleading burden of establishing standing. And here, I'm not sure that they have.
well, I certainly agree that we have to meet it in every case, but the reason why it was met in those prior cases, it applies exactly the same here. We're talking about the levels of obligations, and lowering the obligations will reduce the demand for renewable fuel and increase the competition with renewable
But
fuel.
isn't this case different because we're talking about past years? Like whether or not RINs need to be retired for 2018, 2017, and 2016, that's not going to affect demand for renewable fuels, either in those years because it's over or prospectively.
No, that is incorrect. If I may, just one more point in response to Judge Rao, and then I'll answer your question. The final point is the Ohio case. The petitioners there, the problem with their theory of standing was that the automakers had already voluntarily agreed to meet or exceed EPA's standards. So even if EPA standards were reversed, it would not affect the production or the transition into electric vehicles. That's not the situation here. The obligated parties are not promising to meet their obligations, even if not
Any evidence about that one way or another, right? I mean, the RFS obligations set a floor, but we don't know. I mean, will people blend more renewable fuels? Like there are so many different things that could happen in the marketplace, and it depends on lots of independent decisions of third parties that are being regulated.
It doesn't here. It depends on the obligation, which creates which creates the amount of competition. It creates a zone of exclusivity for renewable fuel and a zone of competition. And whenever an agency moves that line and invites additional competition, there's injury to the party that now has to face competition that it wouldn't otherwise face. And to answer your question, Judge Pan, it is about the future and it is about demand. There are RINs in the bank that would not be there if EPA had denied the exemptions and then required compliance. And those RINs can be used in the future.
They expire.
No, they roll from year to year. As
Only
an
one
individual,
year, only 1 year forward from the compliance year.
yes, but that's not how it works in practice. Each RIN expires 1 year after its year of generation. However, the bank rolls from year to year. EPA has explained this in its rulemakings multiple times. Every year, obligated parties first use all the old RINs to meet their obligations. Then they use new RINs to meet the difference in their obligations. And if they've got more new RINs left over, they put those in the bank. The result is that old RINs become new RINs in the bank year to year. And as EPA's term for this is mediating obligations across years. So right now,
I thought they couldn't do that. I mean, this isn't really squarely an issue here, so I haven't reviewed it. But if you carry forward, don't you have to then meet all the next years? You can't continually, and no individual can continually carry forward.
that's correct. But we have a series of unlawful actions by EPA. The 2016 general waiver, which was vacated in the Americans for Clean Energy case. And then we have the initial grants of exemptions that are the subject of this case and the prior one. As a result of those actions, the amount of RINs that were required to be retired was lower than the amount of renewable fuel that was actually generated and should have been retired had EPA not committed those errors. That inflated the bank. Then those RINs got rolled into newer vintages and so on. There's still a bank out there. It was 1.8 billion at the time of the alternative compliance action, and the obligations covered by the alternative compliance action is 1.6 billion. That means that all those RINs from the incorrect exemption denials, the initial denials, are sitting in the bank. They have a different vintage, a different ID number, but that bank wouldn't be there if the compliance had been required as properly, as EPA eventually determined it should have been. Now they're in the bank. In some future year, it could be 24, it could be 25, we don't know because there's uncertainty right now. But once this gets resolved, depending on the obligations that EPA sets for a future year, obligated parties can draw down that bank and use it to comply instead of using more renewable fuel. And that
How
suppresses.
do obligated parties access the bank?
They're in the market. They buy RINs and then they retire them. It's not like there's not a single repository. The bank is just a colloquial term for saying all excess RINs that were generated and carried over. And that rolls from year to year. It doesn't evaporate. The RIN evaporates, but it gets converted into a more recent vintage RIN. And so the bank stays constant until obligated parties draw it down. Why do they draw it down? To avoid their obligation to use more renewable fuel, which is the exact thing the program was designed to do. So there's real impact here. We're not talking about past years. We're talking about past years that have been mediated into future years through the RIN bank.
Mr. Lane, if we were to, for purposes of the question for clarifying your position, if we were to grant the petitions in 22-1073 and vacate this latest round of denials, what should we do with this compliance action? EPA wants us to remand to the agency so it can evaluate its next steps. Would you oppose such remand? Would your challenges become obsolete? What do we do?
If you were to vacate the exemptions and remand them, then I assume that the alternative compliance action would basically become moot unless EPA were to re-deny the exemptions on remand, at which point EPA might reissue the alternative compliance action for those re-denials, and then we'd be right back here.
So they're sort of moot in a very specific way, and they're unripe with respect to any future action. They're sort of a non-issue.
Yeah,
They're not
correct, because the alternative compliance action was taken only because EPA denied the exemptions after initially granting them. If that denial goes away, then there's no sort of occasion to need to issue alternative compliance actions.
And not technically moot.
I don't know what the technical,
Okay.
label to put on it would be, but
Would you oppose remand to EPA in that circumstance?
I think our deal would be that you would say something to really constrain its discretion on remand, but if you felt like the premise of this case no longer existed, then it might make sense for you to.
But do they
to
both
remand.
get vacated together, both the denial orders and the alternative compliance orders? I mean, aren't they sort of a package? So if we were to vacate the denial orders,
If you
would
vacated
this
the
court
denial orders,
necessarily vacate the compliance orders along with them?
I think that would make practical sense. The reverse, of course, is not true, although not in a way that I would like. You could affirm the exemption denials, but also affirm the alternative compliance. But the two are, beyond the practical question of this linking that we're talking about, the two are interrelated because all of the retroactivity issues that were discussed in the first case are present and arguably properly present only in our case. Because in adjudication context, EPA is supposed to apply the rule as it exists at the time, and that would result in denial. The question of whether to withhold retroactive effect is really what the alternative compliance action is about, not the denial action. And
I guess if we were to affirm the denials for company A and B, then we would still have to reach the alternative compliance, its validity.
I suppose I'm not sure if the alternative compliance covers those
Not cover.
because they weren't, well, I'm not sure because I don't know if they specifically received the exemption denials in the first place back in 2016 to 18. That's the linchpin for EPA's alternative compliance action. But from a retroactivity standpoint, there are a number of points to make, but where I think I should start is what was the state of play when the small refineries sought their exemptions or even during the relevant compliance years of 2016 to 18? I'd like to really clarify, this is certainly a topic of discussion in the prior case, but I think I need to clarify what was going on. EPA timely issued obligations for those years, for 16, 17, 18, also for 19 and 20. They were on the books before the year began. Under Hermes and under Monroe Energy, at that point, the obligated parties had to expect to take reasonable preparation to comply and could not have expected to receive discretionary relief from their obligations. What happened? So then we can narrow the focus. Was there some sort of abrupt change in how EPA was going to evaluate exemption petitions? Did EPA not put the obligated parties on notice of what they would need to do to get exemptions? Well, there's really two components to the exemption decisions. There's the causation requirement and there's the pass-through analysis. The causation requirement, EPA and DOE had always said that RFS compliance must cause the hardship. Now, that does not mean that they would disregard other factors. It means that if the hardship would exist, irrespective of compliance, there could not be an exemption. But if the hardship might exist as a result of compliance plus other factors, then those other factors could be relevant. EPA reaffirmed this in its 2016 memorandum. DOE said it in the 2011 study. That was the causation standard. Then you have the pass-through analysis. DOE had always been saying that net RIN cost and RIN pass-through would be relevant. However, they didn't have the data on it. It wasn't until May 2015, the first EPA study that says obligated parties can recoup all of their RIN costs, and they could do it, and the study says it, and it's in the record, it's in the JA at 108 or 106, is where it begins, that they could do it by entering brokerage contracts or taking other steps to ensure that they acquire their RINs concurrently.
How does this go to your challenge to the compliance action as opposed to the denial order?
It's
in our previous case.
Because it's about retroactivity. What did EPA suddenly change its approach after the fact in some way that unsettles justifiable reliance? And my point is, there was no justifiable reliance that they were going to get the exemptions, or that they would get the exemptions without ratably buying RINs. Now, that's 2015, right before the 2016 year, which is the first year at issue here. Once you know those things, once you know there's a causation requirement and that RIN costs can be passed through and that ratable acquisition is on the table, it's reasonably within your expectation that you should be doing that rather than doing either a less efficient form of compliance or one that is betting. What they're really saying is that they want an asymmetry. If when they sell their fuel, they get a RIN premium on top of their fuel, okay? They put that in their pocket. Then they have to go out and acquire RINs. That's a cost. EPA says those two things can negate each other if you acquire ratably. What they want is when RIN prices go down, they want to put the difference, they want to keep the difference. And when RIN prices go up, they want to keep all of the RIN premium and be completely absolved of their compliance obligation. And I don't think that was a reasonable expectation going into 2016, 17, or 18. I'm over time, but I do have some additional
And we're
points.
on a schedule. So we're going to thank you. And unless there are further questions, we're going to hear from, is it
Thank you.
Mr. Griot or Glio?
Creo is closer. It's actually Grillio. It used to be
Grillio.
IoT long ago, and I got dropped in immigration. But I'm here representing EPA. It's the important point. And first, I'm for the schedule addressing gross arguments. Their petition here should be denied because EPA had authority and reasonably acted to preserve the RFS program. My friend on the other side orients you to the situation at the time, and I think that's important to do. At the time the EPA took the compliance action, it was concurrent with the denial action. And at that point in 2018, for the 2018 compliance year, there have been 31 refineries that had received grants and had their RINs returned to them. Those grants have been challenged, brought up to this court. They're ultimately remanded to EPA, and then EPA denied them as part of the denial action. So for those 31 refineries that had initially received grants back in 2018, they now had denials and therefore concurrent compliance obligations. What EPA did is it said, what happens if we require them to comply? And we looked at the situation, and there are 1.6 billion RINs that would need to be retired in very short order. And EPA reasonably determined that that would cause significant obstacles, insurmountable obstacles, in fact, to the ongoing functioning of the RFS program for everyone.
So where's the statutory authority for making that determination? I mean, the statute is very specific. It gives EPA a lot of very particular authorities to set up the RIN credit system, to generate the use of credits for RFS obligations, to deal with deficits and surpluses, to do the hardship exemption.
Certainly, Your Honor.
And those are all very specific authorities. And it seems that EPA has exercised some other authority that's not really in the statute.
So what EPA did was, Congress gave EPA a mandate to carry out the RFS program as a whole. And that included a compliance credit system that includes this carryover RIN system that we've discussed, where you can use subsequent years for prior years. And so the statute tells EPA to develop regulations for compliance provisions as appropriate to ensure that the overall purpose of the statute is met. And in the EPA's regulations that it developed, EPA determined that they have the flexibility to require the retirement of RINs in any instance identified by EPA. There's some inherent flexibility for EPA within the statute. And as this court has recognized, and the Supreme Court has recognized, regulations can't capture every unique factual situation.
But why not just grant the exemption, right? Just like a political shell game, deny the exemptions, but basically give them the exemptions in an alternative compliance order. Is it just like a labeling issue?
Well,
What's happening?
So when those petitions when those grants that have been challenged were remanded back to the agency. So in 2021, they were looking at everything from a straggle of 2016, 2017, 2018 forward. And EPA reasonably chose to apply its new interpretation, which we just heard my colleagues arguing about, of its interpretation of RIN cost pass-through and its approach. It decided to do so, and reasonably decided to do so, across all pending petitions that were in front of it. It didn't want to say, we're going to grant these and not these, because it wanted to apply the same consistent framework. But then what it did with the compliance actions, it looked at the consequences of that and reasonably said, we need to mitigate those consequences.
But why isn't the consequences of that just other economic factors for granting an exemption? It seems like Congress provided a specific vehicle, grant exemptions when there's been some disproportionate economic hardship. And it seems like what the alternative compliance actions are identifying is that there would be a real hardship to compliance now for years in the past. So why not grant the exemption?
So the difficulty in that situation, the 2018 compliance year was closed. And so there was no opportunity for the refineries to demonstrate and ask for, in the process that we envision, this process in which you submit the information, the burden is on the refineries to show that they're eligible, that they would have to submit this information, that EPA would then consider that information. Instead of going through that process, considering that these obligations were due imminently, EPA decided reasonably to act in the way that it did with the compliance action, instead of requiring the process that you're describing. And the question isn't whether EPA could have done X or could have done Y. The question is whether this action was reasonable. And it was not arbitrary because EPA was reacting.
It also has to have statutory authority to take the alternative compliance action.
Right. So the statutory authority is going to come from this concept that regulations can't adjudicate every unique factual situation, and that it's appropriate and fine for agencies to flesh out through adjudications like this one, the parameters of particular situations, particularly in Niagara Mohawk, in this case in 1967, remedies as when agencies are at the zenith of their ability to have this discretion to maintain the efficiency of the program. I mean, that was the issue that was that was the crux of the issue in Niagara Mohawk, is that EPA, or in that case, it was that the Power Commission was looking to maintain the efficiency of the licensing system for dams in upstate New York. So here, EPA reasonably was acting to maintain the efficiency.
I'm sorry, is it EPA's position that you could not have granted hardship exemptions for the 2018 year? Is that what I heard you say at the beginning of your response, that that would not be possible to grant a hardship exemption?
I think the answer is that it would be impracticable. Whether it was possible or not is an open question, but the process would have required submission of the information showing that it was a hardship. What EPA essentially did, Your Honor, is it determined that this would in fact be a hardship on the program and the system as a whole. And in line with the cases that this court has looked at.
But they did apply for a hardship exemption, but you're just saying that not on this ground, and you can't grant an exemption unless they ask for the specific grounds?
And this is specific to 2018. So the compliance action is specifically for the refineries that had grants, had their RINs returned to them, and now had denials. And so that compliance year was closed. It was not as though they had not yet reached the point at which they needed to make that compliance demonstration. The compliance demonstration had already happened in the past, and they had received grants, and those grants have been challenged. I think that's the key difference between this and other years. The compliance years were still open, in part because EPA took other mitigating actions. The extension rule, the second extension rule that this court heard last summer, in which EPA was attempting to get the program back on track, to sort of give additional flexibility for years that had not yet closed. And that's part of why it's important to understand that that wasn't possible here, because that compliance year had closed for 2018, and the 1.6 billion RIN obligation was due and imminently due. And therefore, requiring that compliance would have placed an unreasonable burden upon these refineries.
I have a kind of related but more specific question about Company A and Company B. If we were to vacate the denials in 22-1073, except with respect to those two companies, would the compliance actions remain in place as to those two? They would still need the compliance action, or would your request for vacator and remand of the compliance actions apply to them too, because of sort of the nature of a core reason for the compliance action was that there would be lots of refineries scrambling for RINs, and if it was only two, no compliance action warranted? What's the position of the EPA in that
2 points, Your Honor.
situation?
One, for companies A and B, they were found to be not eligible. And so the first threshold for eligibility for relief would be to show that they're eligible. So if you in fact vacate on those grounds, the denial on those grounds, they would still have to be evaluated for whether or not they had disproportionate economic hardship. It's a separate question.
If they're not eligible, on what ground would we evaluate?
Well, if you find that they're not eligible,
If we were to find that they were not eligible, then there's no equitable relief for them. They would be, boom, out of compliance the day the opinion issues.
That's correct, Your Honor. And I think the difference between that and the compliance action here, and I think the volume point that you're making, is that it was the size and the scope of the problem that EPA was facing in this unique circumstance, with the 2018 obligations all coming due essentially simultaneously. That's different than one or two companies having compliance obligations because their eligibility is found to come into existence. So we are looking at the systemic structural concerns and the impacts it would have had on the RFS program. And again, importantly, not just the RFS program for small refineries, the RFS program writ large for the entire industry was threatened by the requirement to have 1.6 billion RINs come due.
Why did EPA choose to separate out the denial and the compliance actions in these sort of nominally separate actions?
EPA has the authority to do this, which is not a direct answer to your question. The answer is EPA chose to do this in its discretion. I don't have a firm answer on why. And I don't think it's particularly relevant given that the question here is whether or not what EPA did to address the effects of this specific situation were reasonable.
It relates to Judge Rao's question about the agency's authority. You know, if the compliance actions are exercising EPA's authority under ordinary administrative law principles and principles of adjudication to withhold the consequences of its announcement of a new legal principle, your position is that that's not, the formality of having them be two separate actions doesn't affect that equitable remedial fashioning authority.
That's correct. This is an equitable remedial relief in line with, there's plenty of cases that show that adjudications can have retroactive effects and you can withhold those effects grounded in notions of equity and fairness. Essentially, it's an equity argument. And here, the harm would have been significant, not just to these particular parties, but to the system as a whole. And EPA reasonably decided to mitigate those in the way that it did.
All right. Thank you very much. I guess we'll hear from you again in connection with the other remedies.
May it please the court, Daniel Fife of Sidley Austin for interveners. I'd like to begin by addressing some of Judge Rao's points on standing before turning to statutory authority, and then with my little time, perhaps addressing briefly the issue of remedy. So on the standing issue, I think, Judge Rao, you're exactly right that Growth Energy has not carried its pleading burden here. They haven't even shown that they were injured back in 2016 to 2018 from granting the exemptions during that period, because as you said, the RFS sets a floor. In those years, we know that there were, I believe, 3.5 billion excess RINs generated in 2018, which at a minimum shows that there's reason to think that the floor was not actually doing the work, that what was driving renewable fuel production in those years was actual demand, not the regulatory floor set by the RFS.
Is that?
That cuts the other way.
I'm sorry. Is that in the record? The
I believe that's mentioned in the compliance actions, the total number of RINs going into 2018. Judge Pillard, I don't believe it cuts the other way, because insofar as there are excess RINs, that shows that parties are generating an excess of what the renewable fuel standard is, such that the minimum demand represented by the renewable fuel standard is not what's actually driving renewable fuel production. And therefore, they're not injured by the level of the floor. They're producing simply in response to the market demand.
But now we're post blend wall, post 2013. That is no longer the case.
Well, I think that the point I'm making is that for those years, I believe 2016 to 2018 was also post blend wall, and there were still excess RINs being generated in those years. So
And yet we've held that there was standing for Growth Energy. I'm not sure I'm following.
So where the court has held that there was standing, I think the two cases that they point to, Alone and National Biodiesel Board, those are distinguishable cases. In both of those, the National Biodiesel Board represented 100% of biodiesel fuel production. And so any change in the level would clearly affect one of its producers because those producers represented everybody. That's not the case here. Again, this gets back to the fundamental failure to carry their pleading burden. In fact, you heard in the prior argument, Growth Energy's counsel recognized that the overall size of small refineries in proportion to the overall refining market is relevant to the impact of those small refineries on the renewable fuel producers. There's nothing in the record here that shows that. So it's just, Growth Energy's own counsel acknowledged the fact that he acknowledges relevant to the injury question that they haven't actually introduced record evidence on. Let me quickly turn, if I may, to the statutory authority question that Judge Rao raised. So it is true that EPA can't point to a specific provision that authorizes what it did here. But it is equally true that growth energy can't point to a specific provision that governs here because the statute simply does not address the question of what happens when EPA acts after an applicable statutory deadline, as occurred here. That's precisely the circumstance that is governed by this court's decision in Americans for Clean Energy.
The text and structure of the statute gives EPA some very specific authorities. And then it seems that, EPA has claimed just some additional general authority to make the RFS system function.
Well, Judge Rao, I would not.
I'm not sure if that's compatible with the very specific authorities that Congress gave to the EPA.
So 2 points on that, Judge Rao. First, that was equally true in Americans for Clean Energy. There, the statute set an annual statutory volume obligation, and EPA departed below it, and this court upheld it. And the reason it upheld it is the second part of the answer, which is the court recognized that where an agency acts late, it has a duty grounded in basic principles of due process to mitigate any hardships from its late action. And this case is really a heartland, straightforward application of the obligation to mitigate hardships from late action recognized in Americans for Clean Energy.
So assume that we vacate the denial order, what happens to this case? Is it moot? Is it, must we vacate the compliance orders? Maybe speak a little bit to the remedy.
Sure.
Question.
So I think for the reasons that Judge Pillard identified, the case would not be moot, and it would not be legally moot, and we think as a matter of judicial economy, it wouldn't be appropriate to say that it was moot. I think that there are, two potential possibilities here. One is that the court could hold this case in abeyance pending the outcome of any disposition of the exemption petitions on remand. I think another possibility is that the court could uphold the compliance actions. In other words, deny the petition for review in this case, uphold EPA's compliance action, and then dismiss the corresponding petitions for review in the denial action as moot. Now, I want to be clear that I represent a broad coalition of interveners, and if to the extent the court is interested in this, we would ask for the opportunity to submit a short letter brief on this issue because not all of the interveners are similarly situated, and so the form of relief could affect different ones differently. But I do think that those are kind of the two principal possibilities here. And I think that those are, consistent with, not losing the benefit of all of the briefing and preparation on this case, and they're also consistent with providing interveners with some measure of certainty about their compliance obligations going forward.
I understand where you're coming from. If no harm, then no foul. But it's odd to say we would uphold a alternative compliance scheme without finding that the underlying merits action that supported it actually was valid or not. Maybe I'm misunderstanding.
Ordering is tricky.
Maybe I'm misunderstanding what you're talking about. It does feel like, were we to, let's say, expand the alternative compliance action all the way to 2021, then there's really no issue for the refineries. And so then the question is, well, why are we deciding 22-1073, right? That's sort of the basic intuition that you're expressing.
So yes, I guess the intuition is kind of the inverse of the relief that's being sought in that case. I think that the petitioners in the denial action, if I'm not mistaken, in the alternative, as an alternative to vacating the denial action, ask for the relief granted in this case to be extended to all of the petitions there. I think recognizing that as a practical matter, that will mitigate the harms from the retroactivity in that case. But I think
we couldn't do that without upholding the denial action.
I think
we couldn't not act on the denial action and give that relief.
That may be true, Your Honor.
The alternative compliance is a remedy for the denial action, or it's a mitigation.
Yeah, but given the way that these cases have been teed up, I think this goes back to the separation of the cases. I think that if you were to recognize that the injury has been satisfied by the alternative compliance actions, you wouldn't need to reach the validity of the denials in the first place. I mean, you,
There was an injury from the denial actions that was unlawful. Or no?
well, I think that the bases for EPA's, the bases for EPA's decision in the compliance actions, they assume the lawfulness of the denial. So I don't know that you actually have to conclude that the denials are unlawful to uphold the compliance action here. Again, I do want to sort of clarify my writ here and request that we have the opportunity, if the court is interested, for a letter brief on this because of the different ways that the different dispositions may affect the different interveners in this case. But I think that roughly represents the different ways this could resolve.
All right, I believe your time is up.
Yes.
And we will be hearing from you again.
You won't be hearing from me again.
No, we won't be hearing from you again. We'll be hearing from Mr. Len on rebuttal. Lane.
Either way, I'll respond. Quickly on standing. It's about the future. It's not about the past. As I was explaining with this mediation of obligations and use through time. In the June denial action, EPA recognizes. It said that absent the alternative compliance actions, renewable fuel use would increase. That's at JA 377. Alon refining, on the question of whether there's a difference between national biodiesel and growth energy. Alon refining, although it might have been the fact that MBB represented the whole market, that wasn't the reasoning. The reasoning was that all of the members would be affected by the action. That case was also being decided after the relevant compliance years were over. And there was a recognition that in the future, this would affect use. And because all members participate in the market in an undifferentiated way, they're all affected. It's exactly the same here.
I mean, I think that goes to the question of whether growth energy could demonstrate standing in this case. I mean, my question is whether growth energy has met the pleading burden.
Well, I think it's self-evident based on the precedents.
Much more pled in the Ohio versus EPA case. There were, I think, 10 declarations from economists as to the nature of the market and how it worked. And here we have just one short, declaration from the growth energy CEO that doesn't speak to any of these other economic factors.
This court's own precedents already established the mechanics of why there's an injury here. Probably the RFS sets the demand. It defines the level of competition.
That doesn't go to your pleading burden, though.
In Wynnewood, this court found sufficient a statement in the record by one refinery CEO that the action would have huge effects for everyone in the market. That's it. That's the totality of the evidence because this is basic economic. It's not drive-by because there's a finding that based on economic principles and the way the program works, that it is necessarily the case that we are going to be injured.
If we've found that in the past, then there's no pleading burden to demonstrate standing for a party?
I think it's self-evident. And when it's self-evident, there isn't a pleading
Is there
burden.
a case that says where it's self-evident?
Sierra Club. I mean, that's this court's rule. If it's self-evident, the petitioner doesn't have to do anything more to show standing. That's been the rule, I don't know,
Not
decades.
self-evident to me. I mean, this is a pretty complex statutory scheme, and
Well, again,
I'm no expert on renewable fuels. It's not self-evident to me.
But again, this.
Are you relying on self-evident?
No, when we put in the declarations, this court's own precedents.
Declaration one.
We had a reply declaration when the interveners raised this in their brief. This court's decisions say RFS standards define the level of demand for renewable fuel. When in the American Fuel case, the court said when exemptions are granted, they create a renewable fuel shortfall. Who bears that? Growth Energy's members. They are the producers of the renewable fuel. When there's a shortfall, it's their product that's not being purchased. I don't think.
Are you representing 100% of the market?
No, but we don't need to. All of our members participate in the market. And that's enough. Each one of them is injured. And that's Alon Refining recognized that. Each member of MBB in that case participated in the market. They're all affected by the level of demand and the access to competition
I
level.
think the thing that's not addressed by any prior case is sort of the weird timing involved in this case, that we're talking about RINs from, past years. So it's just not at all clear to me that these other cases are on point.
That's the case in every single RFS case, because every RFS case is decided after the compliance year has occurred.
And 5 years later? 6 years later.
Some of them were many years later, and it doesn't matter because it's the RIN bank that, again, mediates the obligation to the future.
Where is this theory about the RIN bank you have the burden to explain this to us, and I don't understand it, and it's not in your brief.
I believe we covered it in our briefs. It's all over EPA's documents. Every one of its rules that it issues.
This whole RIN bank, the way it works, is in your brief?
I believe we explained it, and it's also in EPA's own documents. They say it over and over again, that this is how the RIN bank works. And in the June denial, at 377, when they say that not giving the alternative compliance could result in increased renewable fuel use in the future, that's what they're talking about. They're saying because the bank right now is inflated and it will be drawn down to meet these obligations under the exemptions, that will then require new renewable fuel use to meet future obligations. That's simply the mechanism of the program. I do want to make one point about the alternative compliance action on the merits. There are alternatives. The government seems to think that it can't do anything else, but it's done something else many times. It can extend deadline obligations, expand RIN vintages, and draw it on the bank. It did it in Monroe Energy and other cases.
Okay,
Thank you.
thank you. Now we have Counsel for Petitioners, Sinclair and Wynnewood. And we're starting with the EPA's treatment of the 2018 petitions, and you must be Mr. Homestead.
That's correct, Your Honor. Thank you. May it please the court, I'm Jeff Homestead from Bracewell for Sinclair. I'll be addressing EPA's treatment of Sinclair and 2 points of administrative law that are relevant to both Sinclair and Wynnewood. Mr. Hershey will then be addressing EPA's treatment of Wynnewood and the remedy that both parties are seeking in this case. This case involves two basic principles of administrative law. First, as this court has said many times, agencies must treat like cases alike unless they provide a compelling justification for treating them differently. Second, when taking action, an agency may not simply ignore an important aspect of the situation before it. EPA has violated both these principles in this case with respect to both Sinclair and Wynnewood. EPA's treatment of Sinclair in this case has been outrageous, and I do not use that term lightly. We understand that agencies sometimes make honest mistakes, but even after EPA finally acknowledged its mistake in handling Sinclair's 2018 petition, it has refused to do anything to undo the tens of millions of dollars of harm that this mistake has caused to Sinclair. The record shows that but for that mistake, Sinclair would have been in the identical situation as the 31 small refineries that were covered by the compliance action. We are simply asking the court to require EPA to provide a remedy for its mistake by giving Sinclair the same benefit that it provided to 31 of its competitors. If this court has questions, I'd be pleased to answer them, or I could explain this in a little more detail.
There's a sequencing question about in terms of remedies. So if we assume that we grant the petition in 1073, right? We vacate the denial order, then maybe that makes our ruling on the compliance order moot in some sense. But I wonder if in order to address the Sinclair position, does this court have to determine that the compliance order is within EPA's authority? Because
I think the answer is there must be some way for the court to recognize that EPA's treatment of both Sinclair and Wynnewood, even if we're just talking about a grant of an exemption that is either a few months late or a few years late, that EPA has an obligation to provide a meaningful relief for that. Even if EPA were to grant our exemption tomorrow, that leaves us 5 years without having had the benefit that 31 of our competitors have had. So I'd have to think about
what's the ongoing injury that you're seeking redress for if we were to vacate the denial order?
Well, vacating the denial, even if that results in automatically granting the petition for Sinclair, doesn't do anything to undo the injury. Because even though we were previously granted our exemption, we never received our RINs back. So simply putting our our grant back in place again does not automatically restore the RINs that we should have been given back in August of 2018.
So
It
it's
is-
a position that even if, let's say we were to invalidate the denial actions and remand to the agency, the additional relief that your client seeks, it's in this distinct position from the other petitioners because it wants this Pruitt-Kern Oil additional relief. So your view is that we would still have a basis to rule on that in such a hypothetical situation that the denial action were vacated and remanded?
I believe, I
And the
believe,
general compliance action, whether it's mooted or not ripe or just follows with the denial action, you still think we need to reach the Pruitt-Kern Oil?
I believe so, Your Honor. And certainly it is within this court's equitable powers to mandate that EPA do something to undo the harm that it has caused to both Sinclair and to Wynnewood.
Wouldn't we need to wait until EPA were to grant Wynnewood's petition and revisit the requisite remedy?
So they have granted, but before the action that you would have overturned, the
Yeah.
denial action,
They
EPA,
had granted, but then they'd already denied. So it was pre-denied before the denial action.
right, it was granted,
Denied.
and, well, it wasn't granted and denied.
Granted, held in abeyance, remanded.
Yeah. I guess,
But aren't you in a better position if on remand then you're granted?
I'm sorry, say again?
Aren't you in a better position if we remand and then you get granted an exemption?
We don't know, because the grant of an exemption doesn't do anything to restore our RINs. We've already experienced that one time before. EPA granted our exemption in January of 2021, but then refused to return our RINs.
They would have two obligations to return your RINs if on remand you are granted an exemption.
So we absolutely believe that you should overturn the denial action. That's clear.
Right,
That
the
has
question
a-
is just what to do with this one. If we do that, do we?
There's no
Decide
basis
this?
for
Yeah.
even for the Pruitt-Kern Oil yet. I mean, I'm just not following the basis for Wynnewood to get that relief. If both the denial action and the alternative compliance action were to be remanded to the agency, is your specific relief still before us?
I believe so, Your Honor, because if the denial action is vacated, that restores the exemptions for everyone except for Sinclair. Because EPA, after granting the exemption for Sinclair, then came to us and said they were going to ask to remand everyone's because they wanted to reconsider it. They went to court and then asked the court to remand and vacate. We were under the impression they were going to treat us just like everyone else, but they didn't. They asked the court to remand and vacate. With respect to everyone else, they simply asked for a remand. So we're uniquely harmed by, so even if this court vacates the denial action, we're left holding the bag, even though we received an exemption from EPA based on exactly the same criteria as the other 31 small refineries.
But isn't that because EPA sought voluntarily vacatur and remand in the 10th Circuit and Sinclair didn't oppose that? Why isn't that fatal to the claim for relief? I don't understand why Sinclair allowed that to happen without opposition. Isn't that the actual harm that Sinclair is trying to address?
What we're trying to address is the disparate treatment. That's
I understand,
right.
but that
But-
occurred
right.
when the
We were
exemption it was granted was.
we were told that the reason for seeking the remand was that EPA was going to seek a remand of all the petitions that it had granted in 2018. When they sought remand and vacature of our petition, we didn't know that they were not going to seek the same relief because they had told us they were going to treat us like the other ones. So we had no real basis to oppose that because EPA said that they were going to ask for remand of all of these decisions. And we had already seen that it didn't make any difference if our exemption was in place, because our exemption had been in place for several months and EPA had never returned our RINs. So there was
And during those several months, when Wynnewood got its RINs returned, Sinclair didn't challenge that, for example, with a mandamus action or say like, wait, we're left behind during that January to May period. Didn't file an action saying we're being treated unequally now.
We didn't know we were being treated unequally until EPA later came back and asked for something different in this court. So we had no way of knowing we were being treated differently until, as I said, EPA came and asked for something different in this court than it had asked for in the 10th Circuit.
You didn't know that others had been restored their RINs and that.
No, we knew everyone else had received their RINs back in August of 2019. When we got our exemption finally in January of 2021, we assumed that EPA would do what it had done in every other case and return our RINs. They refused to do that.
Right. So you complained that they were dragging their feet. They were refusing to bring it, but you didn't then file an action.
Yes, we did. We filed it. Well, we filed it.
You filed the district court, EPA.
We filed an action to force EPA to return our RINs. That's when EPA came to us and basically said, don't waste your time. We're going to ask for all the 2018 exemptions, including yours, to be remanded so that we can reconsider them.
I didn't see that in your brief. Did you?
It is in our brief. I know it's in the.
You filed like an APA challenge.
We filed an APA challenge in the 10th Circuit.
Oh.
And that's discussed in the procedural background of sort of the history of EPA's treatment of Sinclair. And it was only after.
That was before.
It was only after we filed that case in the 10th Circuit that EPA came to us and basically said, don't waste your time with this case because we're going to seek a remand of all of the 2018 petitions, exemptions.
Right. Thank you.
Thank you.
And now we'll hear from Mr. Hershey.
Good afternoon, Your Honors. Sam Hershey from Whiting Case on behalf of petitioner Wynnewood Refining Company. You just heard from Mr. Homestead regarding the harm inflicted on Wynnewood's co-petitioner Sinclair. I just want to clarify or clean up a little confusion that may exist between the different facts that affect Sinclair versus Wynnewood, and I'll do that in my presentation. Like Sinclair, Wynnewood obtained a 2018 small refinery exemption from EPA. For reasons I will discuss in a moment, the Fifth Circuit's decision in Calumet, which vacated EPA's attempt to retroactively revoke Wynnewood's exemption, forecloses EPA's attempt to escape accountability as to Wynnewood. After Calumet, the only question is not if Wynnewood is entitled to RIN replacement relief, but when. Wynnewood has spent 5 years in litigation seeking RIN replacement relief from EPA, and Wynnewood has been forced to pursue that litigation despite the fact that Wynnewood has done everything right. Indeed, EPA does not dispute that Wynnewood did everything right. Wynnewood submitted its SRE petition well ahead of the compliance deadline. It retired RINs at the compliance deadline, even though the prior year it had been found to be exempt and believed it would be found to be exempt again when EPA ruled. Wynnewood even purchased RINs ratably, as EPA now counsels small refineries to do. Wynnewood expected that if it followed the law, EPA would do so too. But unfortunately, as has become a pattern with EPA in respect of the RFS, that was not to be. EPA blew the statutory deadline by hundreds of days, and after EPA finally granted Wynnewood's petition, in other words, when the time came to make Wynnewood whole, EPA simply returned the same devalued and expired RINs that Wynnewood had retired months earlier. As a result, Wynnewood suffered tens of millions of dollars of losses solely as a result of EPA's unlawful action. Wynnewood promptly filed suit in federal court, challenging EPA's failure to provide meaningful relief in the form of replacement RINs. Yet despite being on notice of Wynnewood's entitlement to RIN replacement relief, EPA to this day has never provided a valid, timely explanation for its refusal to provide RIN replacement relief to Wynnewood. Indeed, despite a Ninth Circuit decision, Current Oil, requiring EPA to issue the exact relief Wynnewood is seeking here today, EPA continues to defy its legal obligations to remedy the harm caused by its unlawful actions. And that should end today for 3 reasons. First, the compliance action fails by its own terms. In the decision document,
EPA acknowledges that the standard articulated in Americans for Clean Energy is applicable here. In that case, this court recognized that, quote, EPA was bound by our precedents, not to mention basic principles of due process, to reasonably consider and mitigate any hardship caused to obligated parties by reason of its lateness, close quote. The compliance action fails to consider, much less mitigate, the hardships suffered by Wynnewood. There is not a single word addressing the prejudice to Wynnewood from having the RIN replacement relief to which it was indisputably entitled stripped away. Second, the compliance action fails to consider an important aspect of the problem. As the Supreme Court recognized in Regents of the University of California, where alternatives such as Pruitt RIN replacement relief were within the ambit of existing policy, and the decision document contains no discussion of it, that omission alone renders the decision arbitrary and capricious. Nowhere in the decision document, or even the voluminous administrative record, does EPA mention, much less explain, its refusal to provide such relief to Wynnewood. On that basis alone, EPA failed to consider an important aspect of the problem, and remand without vacatur as to Wynnewood is required. Third and finally, the Fifth Circuit's recent Calumet decision vitiates any distinction EPA may seek to draw between this case and Kern Oil. While EPA states for the first time on pages 66 and 67 of its response brief that Wynnewood is not like the parties in Pruitt and Kern Oil because Wynnewood's SRE petition was reportedly denied, that is a post hoc rationalization that cannot be considered by this court. And even if this court were to consider such an argument, the Fifth Circuit's Calumet decision held that EPA's purported revocation of Wynnewood's 2018 SRE petition was impermissibly retroactive.
Would the place to get your Kern Oil relief be in the Fifth Circuit on remand? In the EPA on remand from the Fifth Circuit?
I don't believe so, Your Honor. We challenged the compliance action in the Fifth Circuit, and that case was transferred here because the Fifth Circuit determined this court had jurisdiction. So I believe we are properly before this court. And Your Honor, may I quickly address the Kern Oil relief that we are seeking?
Yes, you have a minute.
Okay, a minute is all I think I need. The relief we are seeking today is a Kern Oil instruction to EPA to issue replacement RINs to Wynnewood and Sinclair. Because the fact is, EPA has demonstrated time and again that it cannot be trusted to do the right thing. Given EPA's history under the RFS program, this court must make EPA do the right thing, just as the Ninth Circuit did in Kern Oil. And I'll note that the only distinction that EPA has ever drawn between Wynnewood and the petitioners in Kern Oil is that Wynnewood's SRE petition was reportedly denied. That denial has been ruled null and void by the Fifth Circuit's decision in Calumet.
Where does our authority come from to order that type of specific relief?
Yes, Your Honor. Well,
I understand the Ninth Circuit did so in Kern Oil, but where does what is our lawful authority for that?
Well,
we could vacate the compliance order. We can remand.
Yeah.
You're asking for something much more specific, a specific direction for them to do a particular thing.
So, Your Honor, under the Regents case, EPA is required to consider options that are within the ambit of the policy, and EPA has not considered those. This is the only option that would treat Wynnewood similar to similarly situated parties in Pruitt and Kern Oil, and EPA has demonstrated it's not going to do that. So this court could absolutely write EPA a blank check on remand to do what it deems appropriate, but we know from experience that EPA is not going to do that. And so I think it's within the authority of this court to direct EPA to do the right thing and to treat Wynnewood similar to similarly situated parties. I'll note we cite a number of cases in our brief, the Baez-Sanchez case, others, where courts have directed administrative agencies to take certain action, where the agency has repeatedly failed to follow the law and to treat similarly situated parties similarly in this case.
All right.
Thank you so much.
And then we're hearing again from Mr. Grillo.
Really, that's right. Good afternoon, Your Honor. Sinclair and Wynnewood are asking for relief premised on exemptions they don't have. They both have denials and no further relief is warranted.
So if EPA on remand were to grant Wynnewood's exemption, then that would be the time to consider Kern Oil relief, or no?
That's a different hypothetical situation, and EPA's action.
Hypothetical situation.
EPA's action in light of granting Wynnewood's exemption should be evaluated in the light of the decision they make at that time. And it's worth noting that Wynnewood does not in fact have a grant at this point. The Fifth Circuit has vacated and remanded, but EPA has not yet acted on that.
Neither has an exemption that springs back into life if the denial action is.
It's EPA's position that their obligations are pending right now. It's back in the decision. The ball is in EPA's court to make this decision at this time.
Okay.
But, wait, I mean, can this court order EPA to issue replacement RINs?
No, Your Honor. In short, EPA.
What about Kern Oil?
So Kern Oil was a very specific situation in which Kern had received a grant after EPA's deadline for making the decision. So in that instance, Kern had a grant. In this case, Wynnewood does not. Wynnewood has a denial, and so does Sinclair. And so in this situation, the compliance action reasonably addressed the implications on the ARFIS program as a whole and made a decision to not force additional compliance. So Wynnewood already got its RINs back in 2019. The effect of the compliance action is that they get to keep those. We don't necessarily agree that that's proper, but given the impacts on the overall system as a whole, we took the compliance action. So the Kern remedy here would be wholly inappropriate for this court to order because Wynnewood does not have a grant. Kern had a grant. In Pruitt, EPA initially denied the petition. The 10th Circuit vacated and remanded. On remand, EPA granted, and there provided replacement relief. In that case, Pruitt had a grant. That's the important distinction. That's the relevant distinction. And in order here to grant Wynnewood RIN replacement relief would be inappropriate.
All right. We don't have more questions, and so there's no reason to use your time unless.
I want to address one point that came up in the discussion with the interveners is what would happen if you were to vacate the denial action? What would the implications be for the compliance action? In EPA's view, I think my colleague, the interviewer, laid out two options. EPA would propose a third, which would be a remand without vacatur, given the Allied signal test, which would essentially mean that the compliance obligations would not spring back into existence while EPA figured out the implications of the denial action.
And are you asking for that?
No, Your Honor. I'm merely raising the point. I think that the denial actions were properly decided, and accordingly, the compliance actions were properly decided.
But if we were to hold that, if we were to grant the petitions with respect to the denial action and accordingly the alternative compliance, are you asking us to remand without vacatur rather than vacate and remand?
That's correct.
You are.
So yes.
To remand the compliance order without vacating.
The alternative compliance action, meaning that the 2018 compliance obligations would remain, that the effect of the compliance action would remain while EPA reconsidered the implications going forward. So that we do not essentially create this problem that we are trying to solve.
But you're not asking for that with respect to, well, it would depend on the basis, but you're not asking for that if we were to vacate and remand the denial order. No reason to think that that could be an Allied signal.
Oh, I have no, right.
Yeah.
That's correct. I'm not addressing the proper course in the instance of the denial action.
And are Company A and Company B subject to the alternative compliance action with respect to their 2018 hardship?
I don't believe so, Your Honor. I do not believe they're in the bucket of refineries that had grants, had their RINs returned to them, and then later had those grants denied. I think they were deemed to be ineligible for different reasons. But that's my understanding.
If we were to remand without vacating the alternative compliance action, would that be effectively a holding that EPA has the authority to undertake the alternative compliance action?
EPA has the authority to take the alternative compliance action.
I understand if EPA believes that they have the authority to do that, but would that be a holding from this court that we agree that EPA has the authority to take the alternative compliance action? I do think a lot of this remedial decision tree is a bit tricky.
Yes, I believe that it would.
I mean, implicitly, it would be suggesting that EPA has this authority.
Correct, Your Honor. That's a good way to put it.
The action would be staying in effect.
Right. So it would be suggesting, but I do not think it would necessarily be necessary to reach that affirmative conclusion in order to take that action.
On whether the company A and company B are covered, I at least see company A in a JA 22 for.
For the compliance action?
Mhm.
Okay. Meaning that they received grants and had their RINs returned to them?
It says small refinery obligations governed by this action.
I'm happy to follow up as necessary. It's not a question I was.
Okay.
Thank you.
Thank you. You win the prize for not using all your time. Of course, there's still contenders. Mr. Homestead.
Somebody should bring the judge's lunch.
I will be brief. I simply want to call the court's attention to this decision at TNA Merchants Project, where it said that an agency like a court can undo what is wrongfully done by virtue of its order. Otherwise, without that power, regulated parties can be substantially and irreparably injured by agency errors, which is what has happened here. If agencies have that authority, courts have the ability to order them to take those actions. I just urge you not to leave Sinclair out in the cold again. This court and the Ninth Circuit, in some cases, have been so frustrated by the way EPA has handled these small refinery exemptions that it has ordered unusual reliefs. In the Sinclair case, previously, this court noted that in light of EPA's delays in making decisions, it had to make a decision within 90 days. In the current oil case, the Ninth Circuit originally just gave a blank check remand back to EPA. And when EPA failed to provide relief, it ordered specific reliefs that they grant replacement RINs and that they do so within 90 days. In light of EPA's outrageous treatment towards Sinclair and Wynnewood, we believe it's within the court's equitable jurisdiction to order that type of relief here. Simply remanding either the denial action or the compliance action, especially a remand without vacature, just leaves Sinclair out in the cold again, having been treated unfairly by EPA since 2019. Thank you.
Done. And then we have Mr. Hershey.
Thank you, Your Honor. So once again, Sam Hershey from Wyoming case for Wynnewood Refining Company. Mr. Grillo says that Wynnewood's petition was denied. It has a denial. That is simply not the case. The Fifth Circuit could have remanded without vacatur. That's not what happened here. The Fifth Circuit vacated EPA's decision to attempt to retroactively revoke Wynnewood's petition, the grant of Wynnewood's petition. As we've discussed in our brief, when a decision is vacated, it cannot be relied on for any purpose. It is null and void. And C-Train and the long line of progeny that comes from that case stand for the proposition that a legally vested property right, which is exactly what the Fifth Circuit found the statutory entitlement to an SRE exemption that Wynnewood had, cannot be retroactively revoked. It cannot happen without statutory authority, which the Fifth Circuit found does not exist here. So it is not the case that Wynnewood's petition is denied. It was granted. The attempt to deny it was invalid and has been voided and vacated. The second point I want to make is, I think, a very simple statement of how the law should operate. First, EPA has to follow the law. I think we can all agree on that. And second, when EPA does not follow the law, it has to mitigate the hardship that it inflicts as a result of its violation of the law. This is the standard that EPA takes onto itself in the compliance action when it says it's bound by Americans for Clean Energy to consider and mitigate hardship. But what EPA is saying is, yes, we violated law when we delayed granting Wynnewood's petition by 235 days, causing them tens of millions of dollars of damages. Yes, we violated the law, or the Fifth Circuit found we violated the law, when we sought to retroactively revoke the grant of Wynnewood's petition without statutory authority, contrary to the law. And this court should just grant us a blank remand to do what we want going forward. In other words, EPA has not committed to mitigating hardship, and we will be right back here with EPA violating law in some new way that we are going to have to challenge. After 5 years of litigation, we would respectfully submit the Ninth Circuit got it right, and other courts that we cited in our brief got it right. When an administrative agency repeatedly fails to follow the law and mitigate hardship, it is to this court, as a co-equal branch of government, to require them to do so, and that's the relief we would respectfully request. Unless there are any questions, I thank you very much.
Thank you.
Thank you.
Case is submitted.
Yeah. The Honorable Deputy Director until Friday, April 19th at 9:30 a.m.